Yeah, yes. So back to item number 3 and 4. So my senior had some personal difficulties today. Also, please matter after 2 days. Also.
After
2 days.
2 days. 2 days will not be possible. After 2 weeks. On the prayer of learned counsel for the appellant, made with the consent of the opposite party, hearing of this appeal stands or these appeals could stand adjourned for 2 weeks. Listed.
Problem.
For hearing item 1.
Yes.
This is the father matter also. Only Mr. Azan, he is appearing in this case. She is not well today. I have been informed today morning also.
Who is appearing?
No, for State Lordship and Azan.
This is a partner matter.
She is not well, Lordship, today.
We'll have it day after tomorrow then. Day after tomorrow.
My lord.
Day after tomorrow.
No, Lordship, can it be tomorrow, Lordship? Because day after tomorrow, one matter fixed with my Lordship.
Tomorrow not possible. Then it will go over.
There, there.
All right, heard Mrs. Kenardi's learned counsel appearing for the appellant. We are informed that the learned additional PP Assam, Ms. S. Jahan,
My lord.
who is handling this brief, is unwell and therefore has not been able to come to court today. First up, on such ground, some accommodation has been sought on behalf of the state. First up, this is a partnered matter and was fixed today for further hearing. First up, however, taking note of the ground on which the prayer for adjournment has been made, we are inclined to allow the same. Let this appeal be listed again on what is the day after tomorrow? 5/1/2023 as a fixed item.
Much of this.
So some arrangement, alternative arrangement you make if she is not well.
My lord.
We can't keep partnered matters like this.
My lord. My lord.
And
I'm obliged.
it upsets our way of
My lord.
hearing cases also. Another matter will come in, then it will become
My lord.
difficult.
I'm like,
Item 2.
My pleasure, lord.
Yes.
This appeal is directed against the order of rejection of bail, madam. Order dated 27/1/2021, passed by Lanas Kechel Nia, in Miss Nia case number 27 of 2020, as of special case number 209. In fact, matter relates to the occurrence of 2016/5/2019, madam.
What is happened to the trial?
Trial is going on, my lord. Evidence is being
Trial
recorded.
has commenced, my lord. Some injured witnesses were examined, my lord. The initial stage, man.
Because as your lordship knows, in 19, there was little difficulty of sitting of the court, etc. Because taking of evidence, it is not that taking of, because courts say that only few witnesses, maybe 2 witnesses or 1 witness a day and all this. Because of this pandemic reason and all this. That is why. Otherwise,
What are the
we could
facts?
have-
What are the facts?
Thanks, your lordship. You ever succeeded, your lordship file. The succeed page 23, my lord. The succeed, my lord. I mean, name is the accused number 4, my lord. There are altogether 8 accused persons. Your lordship has granted bail to 2 of the accused persons, my lord. And allegation against me, my lord, that your lordship will find at that page 53 of my internal page, my lord. Running page 53, my lord, of the succeed.
Page 53.
53.
Yes, please.
Yes, sir. Down below, my lord, 17.22 evidence against Chinmay Lawful, A4.
Hmm.
The role and involvement of accused Chinmay Lawful emerged during the course of investigation as one of the members of Alpha, independent. Next page, your lord. The accused is a member of Alpha and is involved in carrying out subversive and anti-national activities, including terrorist act. He has provided logistic support to the cadres of Alpha by providing transportation to Alpha independent cadre high cadre and actively participate in terrorist act. He is also actively associated with conspiracy to commit terrorist acts in pursuance of goals of Alpha I with other co-accused. During the custodial examination of Chinmay Law for A4, disclosed that as per direction of Pranamay Rajguru A3, he assembled at the rented house of accused Jahnavi, located at Panjabari near Panjabari Masjid, Satgaon, and this is corroborated by tower location of accused 1, 2, 3, and 4, further corroborated by statements of PWY and PWZ. Accused Chinmay Law along with accused Papu Coach alias Vijay A1 attended a meeting with accused 3 and accused 2 near Jutinyali for a short while, which is corroborated by tower location of accused persons. Then, as for direction of A3 and A4, A1 conducted reconnaissance of the area near Central Mall, Guwahati, for attacking the security forces on duty. This is corroborated with tower location of the accused persons. On 15/5/2019 evening at about 19:40 hours, A4 with A1 reached near Central Mall, Guwahati, riding a motorbike. Chinmay Law was riding the motorbike and A1 was riding the pillion with Chinmay Law, lobbed a grenade, aiming at security force and Central Mall. This is corroborated with a tower location. This is further corroborated by statement of protected witness Y. Statement of witness established that Chinmay Law and A4 and A1 were actively involved in planning and reconnaissance of the targets of terrorist acts. This is corroborated by the tower locations of the mobiles of the accused person and statement of witness Damodar. On revelation made by accused A4, the CDR of the mobile used by A4 was collected from the concerned service provider and studied. It was further found that accused was in telephonic contact with A1 and accused A4 was using a mobile number so and so, used the same mobile to contact A1. Customer application form of mobile number 863-847-0635 received from concerned customer service provider. The subscriber of the same number was Unjan, also resident of Sonapur, but during the arrest of accused in my state was seized from the position of so and so. So that is the evidence that has come out. Now, if you take up lordship page 55, 55 is the there is a mobile location your lordship will find. Mobile location of the photograph your lordship will find. C is Chinmay Law and location of Jahnavi was there, that is JS, it is there, and location of Papu Coach, that is A1, who has lobbed the gun. A different location, not the same. So story that the procedural story that I was riding the motorcycle and he lobbed a grenade while pillion riding. Actually, is not correct in view of this.
So this court has already granted bail to some of the court cases.
And moreover, I'm not a member of Alpha, that I'm coming. Your Lordship may kindly see. Yes, 2 of the accused persons you have granted bail.
Which are the accused persons?
Your Lordship has granted bail to Amit Vallabh Goswami, my lord. That is A5, my lord. A6, my lord. And recently, my lord, A8, Prakash Rajkumar. A6, they were granted bail. And so far as another accused, my lord, it was rejected. Sanjeev Talukar, A7, my lord. Different footing, my lord. They were.
You have the orders.
Court orders, actually, I have not downloaded the my.
You have.
But Vallabh, I have got, my lord. Your Lordship will judgment that.
He was riding the vehicle, man.
Your Lordship,
Motorbike. The other person who was sitting in who has locked it. Clear evidence is there.
that your Lordship may kindly see one witness, I'm just like. That one witness make this clear, my lord. Whether I'm a member of Alpha.
Just a minute. We'll hear both sides. Just a minute.
That your Lordship judgment. So far as
Yes, any appeal has been preferred against this order?
Yes.
Appeal was preferred against this order.
Supreme Court.
The earlier order by which the appellant Amrit Vallabh Goswami was granted bail, has it been challenged?
Yeah, no, we have not.
Not prepared.
Sorry?
That order not, appeal is not prepared.
Appeal was not present at Malur.
No appeal filed.
Amrit Vallabh Goswami is in a different footing than he.
Hmm.
It cannot be equated to
Correct.
the.
Let
Although
him
my
finish,
friend.
let him finish, then you argue. The allegation against him is that he was driving the motorbike.
Exactly, Malur, your lordship will just, because your lordship was reading page 55, just read page 55.
No, let him finish, then we'll hear you. If there is any material to show that
He was riding that motorbike.
and that is the end of the matter, because 43D will come in.
Yeah,
What
that
is
is, that is
this?
it. And he has allowed accused number 1, that is Papu Kos, the alpha.
Let him finish, or you want to argue first? And
No,
then
no,
we'll
no,
hear it?
no, just
Okay.
when your lordship is.
Now basically that is the allegation that he was driving the motorcycle and the A1 was pre-riding. But the technical evidence that has been collected, it belies the procedural case that we are together, And in my statement and before police, so that is not admissible. I have stated that no, I have proposed A1. He came down from my motorcycle, and while I'm going to my residence, I heard the sound.
Actually, you said that he was in your motorcycle.
Cycle, but he did not lock while he was in a motorcycle. He got down, and when I was coming back, then I heard the
Where
sound.
is that statement? Is it a part of the record?
That you're also I'm coming to my that statement you'll also find it.
Hmm.
That you'll also page 75, my lord, is the evidence of one witness, my lord, that is Putul Busho, my lord, who has recorded my statement, my lord.
Hmm.
In 161 statement, my lord, he has corroborated page 75 is this my statement, my lord, that he has reproduced it, my lord, in the 161. Page 75. Chinmay Lord, age 25, was arrested and forwarded to Ormond CBI. Again 14 days police custody, remand for during interrogation. He stated about 6 days back, before his arrest, a telephone call from his mobile number caller identified himself as Pranay Rajguru, asked to meet him at 6 Mile. Accordingly, Chinmay Locker met him at 6 Mile at about 2 p.m. on the day. Pranay Rajguru taken him to his related house located at Panjawari near Namgarh Port. And Chinmay Locker, after arrival, found one lady inside the house. And Pranay Rajguru identified her as a sister, Jahnavi. There is A3 and A4. A2 and A3. Jahnavi Saika and Pranay Rajguru assured him to provide a job in a restaurant, which is going to be open shortly. Next day, he again went to the house of Jahnavi Saika, where he found one boy who was identified by Pranay Rajguru, A2 as Vijay Assam, that is A1. He used to visit Jahnavi's house daily by his Khalsa Bhai number so and so, registered in his father's name, and moved with Vijay Ahom in Guwahati 6 Mile, Ganeshguri, Tanmari area, about 5:30 p.m. when he went to the resident house of Jahnavi by his motorcycle. At about 6:15, he along with Vijay Ahom came to Jutinia. He drove his motorcycle and about 7:25, he noticed Jahnavi was standing in front of JNRC Medishop near Guwahati Central Mall. Then he stopped his bike for a while. Vijay Ahom met her and they discussed something. After he then went towards road side, returned U-turn and came towards Guwahati Central Mall, again turning back from Jutinia bus stand. But at that, Dhani was not found in front of JNRC Medishop, and he dropped Vijay Ahom in opposite, in the side of the Guwahati Central Mall, and he went home. He did not confess that he was present with Vijay Ahom at the time of throwing that grenade towards police checking party, though the arrested accused Vijay Ahom, but other accused has implicated him. That is Vijay Ahom and A2 and A3. And that's why, by Lord, the technical evidence says that I was not with Vijay Ahom at that time. I was other side of the road, near the central.
That's all right, but what difference does it make?
That,
Supposing a team of 4
I understand.
persons
That
goes
is
for
the case of the
dacoity.
prosecution is that I was with the motorcycle and he lobbed the motorcycle on the motorcycle.
No, you see, Mr.
Because no,
Kotak,
your lordship and case, there's other evidence I'm coming to. Because there is my own testimony is not having no evidence because there's 161. That's for sake of that is.
No, we are not to look at evidence at this stage. We are not looking at evidence.
I understand. But if your lordship,
Your opinion is being considered only on the basis of materials in the case diary.
yes,
Charge
I
sheet.
understand. Then your lordship may kindly see one protected witness, my lord. That your lordship will find that innocent, my lord.
Yes. Which page?
Page, your page is 85, my 8. Is 86. His name is Gautam Doimani. No, not Gautam Doimani. His protected name is not there, man. His 160 was recorded before Gautam Doimani, special mistake. 86.
Page 86.
86.
Yes.
Presently, I am engaged. That is, there been so Pranay Rajguru was my Facebook friend since long. Since long. That is Pranay Rajguru. He's the accused number 2, my in case. Pranay Rajguru. He was my friend. In March 2009, my friend took me to a house of Jahnavi Anand at Borbari, Pathar, where Pranay Rajguru also resided. On the first day of the meeting, although I knew him, he introduced himself as a member of Alpha Ceasefire Group. On that day, I accompanied him, and it was mentioned that on that day in the evening, I had the opportunity to meet Jahnavi Anand. On the first day of the meeting, there was some formal introduction, and we left away. There was a second meeting, either at the end of March 2019 or beginning of 2019 at the house of Jahnavi. On that day, Pranay Rajguru explained to us regarding the project of making a documentary on the victim of secret killing, Operation of Bajrang, Operation of Rhino, etc. So same can be exhibited in the international forum. Since 7th of April, the Foundation Day of Alpha. So on second meeting, Pranay Rajguru gave a proposal to hoist Alpha flag somewhere in Guwahati, which we straightly denied. There were 4 or 5 meetings with Pranay Rajguru. One day, he asked my scooty, since we cannot walk properly, he cannot cover. So due to his injury on one of his legs, so which I refused since it was a very risky job to give vehicle to others. I stated I'm pursuing, and there was an examination in the month of May 2009. Prior going to, I introduced that then comes the A4 matter. Introduced Chinmay Lawkar, who is a friend, who is my friend, to Pranay Rajguru, who was explained regarding the same project, which I mentioned hearing before. Project means your logic, that documentary, my project working documentary film. On that day, we accompanied, and in the evening, we received a phone call from Pranay Rajguru, who told us over phone that he wants to purchase second-hand scooty, to ask us to find out tax for him. Accordingly, we found one second-hand scooty. Since the price of the scooty was high, he denied to purchase it. On the following day, drinks party was organized in the house of Pranay Rajguru at Manjabari. By the time he shifted the house from Borbari to Manjabari, I was invited to the said party since I was supposed to go on the following day, so I turned the offer. On the following day, I went by train. While I was in, I could learn that there was a grenade blast in the front of Guwahati Central Mall. Having learned, I made a phone call to Chinmay Lawkar, asked him regarding the blast, to which he replied, "There is carry a low voice." And yes, there was a bomb blast. On that day, he stated, while riding a bike, how the plane was at he could not understand. He said, prior to the occurrence, I made a phone call to Chinmoy. On that day, he stated to me that Pranay Rajnath introduced to me a man who needed to carry here and there in Guwahati. Subsequently, I could learn that person who threw the grenade was Vijaya. So, from his statement, your lordship, my lord, they had used him. My lord. He was never a member of Alpha. Nor that he knew about the activities, my lord. Your lordship, I can see that. He's a postgraduate Delhi student, my lord. A student of postgraduate in Guwahati University, my lord. This person, my lord, introduced him to them, my lord, for some project, my lord. And they have used his motorcycle, my lord. Whatever, but he never knew that they are going to do anything, my lord. Next step.
From statement of Gautam Daimari, it is clear that he is the one who had introduced the applicant
Yes.
to the accused number 1.
Why?
Oh, it's 1 or 3.
Accused number 3, my
Rajguru.
Rajguru.
And the project was to hoist Alpha flag.
No, prospect was to for not to Alpha Matter. There was documented they want to give on the victims of secret killing, operation of Rhino and operation of Pozong. That is the for that purpose they want to. So they will go for they will regard a project making a documentary films on secret killing and same to be exhibited in international forum. For that purpose, he was called for.
So what we are asking you is,
Yes,
from the evidence you have pointed out, not
Yes.
evidence, the materials.
Materials,
What appears is that the applicant was aware that this person A3 is actively involved as a cadre of Alpha. That he wasn't aware.
Not aware, because they never discussed Alpha thing, but they are saying that there was so many killings. So we want to make a documentary. So we want to go to the villages and collect information. So nothing to do with, because he was only 2 days after the incident, he was introduced 2 days back before the incident only. Otherwise, he was not aware of it. Actually, they was, you will also see the gameplay. They were want to find out the scooter. They didn't get the hold of it scooty man. Then they found that this person was having a motorcycle man. So they have induced him that we are going to make it, we come. So they carefully they have planned him and they have used him. Neither he knew about the activities, man, that he was carrying bomb, nothing, man.
All right. Anything else?
Because there is no other witness, my lord, except this witness. There is no other witness who knew this because he was not neither member of not the other witnesses not aware of anything.
UAPA Act. Yes. You have the orders by which bail was rejected by this court. Do you have a copy of any of those orders?
No.
Some
Yes, court number 2, my lord, recently, my lord, passed an order, my lord, granting bail to one of the accused and rejected another accused.
Achha, this court has not rejected.
This court.
Who was granted bail and who was rejected?
That is, I'm coming, my lord.
He ordered,
This is the 8, my lord, he was granted bail, my lord. Prakash Raskor, my lord.
And who was rejected?
Rejected is A7, man, Sanjeev Talukdar, man. Rejected.
Do you have the copy?
Those copies are
Mr.
not.
Das, you are also not aware. Nia was not a party.
They are the party, my lord. It was a CAB judgment, my lord. Just before the vacation, my lord.
Can you get the judgment?
The case number, criminal appeal number 136 of 2021. Prakash Rajkot.
136 of 21.
136 of 21.
21.
21.
Yes.
So basically, my case is, your lordship, is that other witnesses, they are seizures, that nothing to do with motorcycle seizures and all. That is not disputed. That motorcycle belongs to my father, and they have somehow induced me to, and it was a game plan of this A3 and A4 as well as A1. And they want to use my motorcycle, man. Earlier they want to go and they didn't purchase a scooty, they didn't, because the price was very high. So ultimately, they somehow managed to take my motorcycle and Because this witness 161 also very clear, my lord. Your lordship will find.
All right.
Okay. If your lordship takes page 89, my lord. This witness is 161. Your lordship will find details he has given, my lord. How he has been introduced, how this person was introduced, my lord. There your lordship will find page 89. Now the language that has been how I mean after I took Chinmoy, that is accused number 4, my lord, to Rajguru. Since Chinmoy was unemployed, was not doing anything. Page 89, your lord. One 61.
Mr. Das, who is there with you in these cases? Maybe that person can counsel. You are not aware what happened to Sanjeev Talukdar's case.
No, but I did the case, but I not aware about the judgment, my lord, because that was given just before the packaging. I'm not aware.
No, but are you aware whether the judgment was delivered or not? That also you're not aware.
I have come to know.
Mr. Dev Chaudhary, would you be able to help? It's very difficult for us when the counsel says, I don't know whether in my case judgment has been delivered or not. It becomes very, very difficult for the court.
In fact, I am also not aware of the.
You're also not aware. Okay. Nobody is aware what is happening.
Yes, the judgment is not there.
Judgment is not there. All right, then we'll take our own view. Yes.
Yes, your lordship, kindly come page 89, my lord. Just few lines, my lord. Down below, my lord. 9 lines from the bottom, my lord. That I took Chinmoy Lawker to Rajguru since Chinmoy Lawker was unemployed, was not doing anything. Initially, Rajguru introduced himself and asked Chinmoy to do what was he was doing. Rajguru said that he had selected all of us, including Chinmoy, for a special task. Asked us if you are willing to do that task. Chinmoy agreed to what Rajguru said. We asked him, what is the, if this we asked him if this task which he was planning is own or someone else or is giving order. Rajguru told us that there's someone above, but did not know who's the person. Later on, we had refreshments in the house. After that, we came out from the house. When we came out, Chinmoy asked me what was the task. I told him the work to be done is intellectual one in nature. Then after we left our respective home, one day I invited for a beer party at the house of Rajguru. I did not go as I wanted to stay home. However, so and so Chinmoy attended the party. Later, told me they enjoyed the party. After one day, I left for Delhi on 10th or 11th May 2000. I stayed for 2 days. Then left my hostel since our exams are start from May. After that, I called Chinmoy when I was in the evening. Then Chinmoy said he was busy. We'll call later. Cut the phone. Later on, 15/5/2019, I called Chinmoy, asked him what he was doing. He told me Rajguru and Janavi and introduced him to another person, and he's roaming around with him nearby. He said he's roaming all over Guwahati. On 15/5/2019, I called Chinmoy from, I do not remember, I've seen the news in the Facebook. The bomb blast happened in Guwahati Central Mall. I called him, asked Chinmoy where he was. He said that he is at home. Then asked him if he knew anything about the bomb blast. He told me he was riding a bike. A person who was riding a bike with him was done it. He said that he did not realize what has happened. I told him that he should be careful. I disturbed. When I came to know that since I was appearing in the exam, so I'm concentrating on the exam, I'm ready to give statement under 160. So your lordship, I can see how he has been, that the game plan of this A3 and A1 to use this person, man. To use this person, my lord. And he was not aware that A1 was having a grenade with him, like, and their activities, my lord. Otherwise, he would not have gone to his home and take rest, my lord, after the incident, my lord. A person, if he's involved in such activities, my lord, should not have come to. So he has been used by these other accused persons. They were searching for a bike. It was a costly affair. Then this found about he was riding a bike. Naturally, my lord, they have by way of inducement, my lord, by deceit, my lord, they have used him. He never knew that there was no intention. Neither he's a member of Alpha, nor he knew about their activities. They are engaging in terrorist act. So there is no knowledge can be attributed to him. If there is no knowledge, where is the intention of causing any terrorist act? That is my submission. And these are only two witnesses, the only witnesses that have been examined against him. Others are Caesar witnesses. These are my submission.
Madam, kindly see two part, madam. One is page, as your lordship, page 55, madam. Page 55. 6, Roman 6. That's one. On 15/5/19 in the evening at so and so hours, Sinmal Locker and Papukos Mokyal, so and so reached near Central Mall Guwahati riding a motorbike. Sinmal Locker was riding the motorbike and Papukos Mokyal, so and so was riding pillion with the Sinmal Locker looked at grenade aiming security forces near Guwahati Mall, which was cooperated with the tower location of the accused. This is further cooperated by protective witness. Why? This is one material. Now, another material, Madam, in his.
Mr. Das, there is just one point to be addressed here. Rest of it you can argue, but will not be of any relevance. He is admitting that he was riding the motorbike where this other accused A1 was in pillion.
I'm aware.
And he got down and he lobbed the grenade. That much is admitted. There's no need to labor for that.
No.
All he is saying is that the applicant was a victim of circumstances because he was roped into this project on a pretext that it was something else. And that is because they wanted a motorbike which they could not buy. So through a common friend, he was taken in.
I appreciate that, Father.
And when the incident happened, the applicant was not aware that this man was going to lob a grenade on the police. Now, is there anything available on record which indicates that he drove the motorbike with the A1 in the pillion, knowing that he was going to lob a grenade?
That intention come from his conduct, because he will not spell that I know him. He was associated. Your Lordship will find in his bail application before the trial court at page 94. Your Lordship will see. I will take your Lordship there. The question is, my lord, you don't allow a person ride on a motorbike unless you are associated or you know something about him. That is one part, my lord. Now, this man, he is a hardcore alpha, this A1. He has come from, I think, Kachin or those parts. Only for that particulars of 15/5/19, loving over. There was a conspiracy in the house of Janavi Sekia, where this accused, he was also present there. It is not that everything has happened on the spur of the moment. It is a big planning. Before that, there were group planning with all these accused persons. Three persons were there. A1 was there, Janavi Sekia was there, A4 was there, and then another Rajguru was there. They planned the whole incident. And when this house was raided, all the materials, I think gun, pistol, and then grenade, etc., everything was recovered. Now, when all these things were there, all materials were there in the house, and this person, A1, who was associated with him and they visited the house. He says that I have no knowledge about it. Mala, that is something because we are not doing a mini trial here, Mala.
That's correct.
We are only about the prima facie case, which 43D5 says.
Try to get that
Your Lordship-
judgment. Get that judgment. Check
Your
out
Lordship
the-
will kindly
Yes.
see his petition before the trial court, Mala.
Hmm.
At page 94.
Hmm.
Because we are
Where is the order of the trial court?
trial court is at page
106.
10. It starts from 106. 106. What is wrong with that? Because we are sitting over this order. What is wrong with that order? How the trial court has appreciated and what is? Is a log test and your Lordship will find.
Yes.
But before
Which
that-
paragraph is the finding?
But before that, Madam, may I just take his bail petition before the trial court, Madam? His bail petition. At page 94, it starts, Madam. I'll take only the relevant paragraph, Madam.
Page
Okay.
94.
94.
Yes.
94. It starts at 94. You also will just turn to page 96 in a page 3, Madam. 96 in a page 3. Madam, the first paragraph, I think just in the middle, but when since A4 was unemployed and was not doing anything, so A3 had informed A4 that he selected all of them, including A4, for doing a special task. But when asked about a special task, A4 told that there is someone above, but he did not disclose who is the person. When witness number Y came out from the house of A3, then A4 asked this witness what the task was. Then the witness did not, witness told him that the work to be done, intellectual one. Therefore, on 9 May 2019, there was a beer party in the residence of A3 and A4 attended the party. Before the occurrence of on 15/5/19, this witness called A4 and asked him what he was doing. Then A4 informed him that on that day, A2 and A3 introduced A1, who wants to come in his bike to look around Guwahati city. Later on, after the blast, when this witness called upon A4 whether he knew anything about the blast, then A4 replied that while he was riding the bike, A1, who was riding pillion with him, suddenly lobbed the grenade. He did not say anything with regard to that. He says that lob. Then your Lordship will turn to page 97, paragraph 4. That a petitioner begs to state that A4 is a victim of so and so, being an unemployed, he was lured away by A3 for doing some intellectual work. Later on, and instead of A2 and A4, he was introduced to A1 and taking advantage of his simplicity and innocence. The A1 was pillion rider, moved around Guwahati city. Later on in the evening, A1 lobbed the grenade at the police party near the central mall. The A4 is nowhere party to the conspiracy to lob the grenade at the Naka Chowk, since it was not within the knowledge that A1 was carrying a grenade and he would lob the same to the police party near the central mall. That is what he has said.
All right.
Then you also will come to the impugn order at page 106.
Where is the relevant part?
Relevant part is one just take, because the first part is the citation.
Page 26, page 26.
page
Para
one-
26, para 26.
Page 120, paragraph 23, it depends, Madam. You only 4 paragraphs. 120. Upon perusal of charge sheet dated 19, I find the paragraph 17.22 of the same enumeration, the finding against the accused Sinma law firm. It is stated that investigation has revealed that accused A4 is associated with Planet Alpha, that he has provided logistic support to Alpha 1 cadre by providing transportation to them, that he was involved in the conspiracy to commit terrorist act and also actively participated in the terrorist act. It is further stated that it is revealed by the investigation that he had assembled at the house, rented house of A2 at Panchabari, Guwahati, along with A3, and that the same is corroborated by the tower location A1, A2, and A3, A4.
All right, we have gone through.
Then next, paragraph 24.
Anything you want to say in reply?
Finding my court has stated that
So, Mr. Kotoke, we will only see whether para 26 observations are valid or not.
yes, yeah, but
If
he
we
has
find
said-
it is valid, we'll dismiss the offense.
then he said that one thing, my lord.
Hmm.
So
So how do you meet this observation that supposing he was not aware,
yes, ma'am.
what was his conduct thereafter? He never informed the matter.
No, he never knew that he shoot a grenade, my lord. Later on, when he came in the news, then he came to know, my lord.
Hmm.
Otherwise, he would not have gone to his residence, my lord.
No, but even after it came to the news, he did nothing.
We also your police arrested him subsequently, my lord.
No, that is when the police found out.
Okay.
But on his own, he didn't.
Yeah, well, only he didn't want it, but maybe because in the Facebook he has stated with the other friend, my lord, witness number Y, my lord. He has warned him that not to go anywhere. Stay, otherwise police will come after you. So he became scared, my lord. Otherwise, he was not scared early. Your lordship, I kindly see his conduct. It's totally innocent. He doesn't know anything, my lord.
All right. That's all. What else? We're not going to write a 20-page
Because-
judgment here.
We are not connected, as your lordship with that 2019 judgment, my lord. No, we are not conducting a mini trial here, my lord, to appreciate the whole evidence, etc.
2019, which judgment? Which judgment?
No, judgment,
Lord.
but
There is a
2019, judgment.
Watali, my lord.
But yeah, but 2019 5 SCC 1.
Watali.
Watali,
Yeah.
Watali.
That is a because we are only trying to see the prima facie.
তেওঁলোকে ক'লে দুটা বেলেগ বেলেগ এপিল এটা দিছে এটা নাই দিয়া যোনটো দিয়া নাই সেইটোৱে লাগে
We are only trying to see whether there is a prima facie material. That is all.
Yes.
And
On Nakib judgment, I'm relying on your lordship that they may look into that. That is on period of incarnation, right? And in the case of the taxation nature, whether if there is an incarnation for more than 4 or 5 years, because I mean more than nearly 4 years, 3.5 years, I mean custody, my lord. And today only 3 witnesses have been examined, my lord. It will take another 10 years to complete the trial, my lord. So on this ground, my lord, this
and what is the maximum punishment?
because 120, 121 will not come against me, my lord. At base, I am not a member of
Right.
Alpha also. So assisting in terrorist act, my lord. That
UAP will come.
yeah, 10 years, minimum 10 years, my lord.
Minimum 10 years, maximum.
life, my lord,
My
life,
maximum is life.
life.
Because 16, 17 has been given to me, my lord, that 18 punishment for conspiracy, my lord. Because I am not a conspirator, conspiracy will not come. Then comes punishment for harboring, 19. Harboring also is not there, my lord. Then comes 30, 38, my lord.
So your only case is that your client did not know about it.
We never knew about it.
That is some matter. Can the court decide at this stage of a bail, considering a bail application?
Because primary facie I get satisfied from the materials.
Hmm.
That knowledge cannot be attributed to me by on the evidence of the witness.
No,
Understand.
but where is that material to show? There should be some positive material to show.
But
that.
because of the witness, evidence of witness, why? Evidence of witness, why we clearly show how I have been introduced into that part.
That's correct, but that does not prima facie exonerate your client.
Acknowledge you said that I had no knowledge about that they're going to plan to such an incident, my lord.
No, Mr. Kottagi, you see, there are two things here,
Yes, my lord.
and subject to what you say, we will consider. In a criminal trial, the knowledge and intent has to be established by the prosecution.
I understand, my lord.
Correct.
Yes.
You don't have to say anything.
Yes, my lord.
But when you are seeking bail
Yes,
and setting aside of an order rejecting the bail
Yes, ma'am.
application, on the only ground, you are not denying the involvement insofar as riding the bike is concerned. On the only ground that you did not have the knowledge that they were
Yes,
going
ma'am.
to lob the grenade on the police party.
Yes.
Then you have the onus will be on you to show that from some material that for this reason it cannot be said that you had knowledge about the.
Yes, my lord. That's what I'm saying, my lord.
So if a witness did not say that he had the knowledge, that doesn't mean.
The
there is no
witness,
material.
witness states about my conduct, my lord. How I've been introduced to that.
Correct. So the learned trial court says that this plea that the applicant did not have knowledge cannot be accepted, because if he really meant it, he could have done many things after the incident. He could have.
He would have reported to the police.
Exactly.
That is the line, last line here. But fact remains that I was not aware that A1 has dropped the grenade, because you are only when I came in the news, then only I was there inside my home, my lord, at that time. When my friend.
No, the protected witness said, then you be careful.
Yes, so necessarily, my lord, I was not aware that actually that it was lobbed by A1. Later on, I came to know, because he came down. I was not riding the motorcycle at that point of time. He was not with me, major, because technical evidence says, otherwise not mine. Because technical evidence says that I was not with A1 at that point of time.
All right. We'll go through the record.
And that corroborates my testimony, madam, before police.
So everything is there on record. There is no need for the case diary here. The statement of the witnesses are there, charge sheet is there. Is it not, Mr.
Yes.
Das?
Yes, yes.
Mr. Das,
No.
we don't need the case diary, everything is here.
I've got a case to happen.
Only point is that just one line. Language is 4-1, what that is. D says, 43 D says that primary facie true.
Prima facie?
True it should be. The prosecution case should be primary facie.
That's correct. That's
Yeah.
what.
So I want to say that primary facie case is not primary facie. In view of this matter. That is my submission, your lord. In view of my testimony before the police. And that is corroborated by technical evidence. And further corroborated by the evidence.
No, but on what basis we hold that prima facie, it appears that he didn't have knowledge?
Because of testimony, because of my own testimony before the police, and that too evidence of 164 evidence by the witness man. That is prosecution witness, that's not my witness. They're relying upon it, and he has categorized how he has introduced me.
But just a sentence, my lord. At page 96, you also will find that it is his statement whether he knew about the blast. Then A4 replied that A4 is similar. While he was riding the bike, A1 was riding pillion with him. Suddenly he lobbed the grenade. Now, if he had the knowledge that actually he was not, he didn't know that he was not carrying grenade, etc., and all saying he knew nothing about this. Immediately, his conduct would have been called to the police, reported that yes, this is what has happened.
All right, heard Mr. P. Kottagi, counsel appearing for the appellant, also heard Mr. Vipladas, senior counsel, explained by Miss
GD Chaudhary.
GD Chaudhary, counsel appearing for the respondent, bracket near. Arguments concluded, judgment read. Yes. You hand over the CD.
Place a CD, mother.
On that matter, 11.
Supplementary list for motion item 6.
Yes, what is this matter?
Lord, this is habeas corpus petition,
Hmm.
and in our humble opinion, my lord, the guard has been kept in woman's house
Hmm.
for no legal reasons. I'll satisfy your lordship on this points, my lord. Now, lordship may kindly see our writ petition.
Hmm.
From annexes, first I am drawing your lordship kind attention to annexes. That is, my lord, page 13. Page 13. This is the high school living certificate examination of 2021. The girl's name is Anjuma Khatun. Page 13. Anjuma Khatun, her date of birth is recorded as 3/7/2004. So, my lord, she is more than 18 years. This is the first document, my lord. Now, second thing, lordship may kindly see, she got married. That is the marriage, Kaji's marriage certificate, page 14. Is the English translation, and the original one, direction may be seen page 15, madam. Page 15, she has got married on 5/7/2022. And her date of birth has been also recorded 3/7/2004, as has been recorded in the matriculation certificate. So she has got married with Omar Farooq. Now, lordship, this Omar Farooq was arrested in this case on the ground of kidnapping. But this Honorable High Court, on the basis of the matriculation certificate and on the basis of our statement, has granted him absolute bail. Learned lower court rejected.
So what is the issue today?
Issue today is the, my lord, our prayer is this. The girl, though major and duly got married, but she has been kept in a woman's house since last 3 months.
Why? Under which
That
order?
is, my lord, so many inquiries have gone. Lordship may kindly see the earlier
Mr.
order.
Mahmood, you will say after, let's finish the matter
Yes.
first, then you make your argument.
Yes.
Please answer the question.
Yeah.
Under whose order has she been kept in the woman's
As
house?
per the order of the Honorable High Court.
Which order?
So many orders are there, my lord. Then just now, I am drawing lordship attention. Kindly see, first order was first, that is 31/10/2022. On that day, the Superintendent of Police, Durham,
Which order? Please pass on a copy.
first order, then lordship, that was
That order was passed in which case?
in this case. In this case,
In this case.
yes. Yes, at 11/11/22. By this order, she was kept in state home for women,
11/11.
22. And learned government advocate was asked.
No,
Thereafter,
but not 11/11/22. 11/11/22 says that the court was informed that she has been kept in the state home for women, which is the order by which she was asked to be kept in the state home for women. Which is the order?
At first, my lord, she was directed to be kept in the district women's committee.
Which is the order?
Which
Which is
that
the order?
order was first followed by learned lower courts. That order may be seen in the
Just now
petition.
you said High Court, then you are saying what?
From there, it was.
You tell us when you want the matter to be, you have to be prepared, Mr. Mahmood. That kind of arguments will not work in this court.
I'm
You have to be
satisfied.
prepared. Yes, give
Now-
correct answers to our questions.
Now,
By which order, Mr. Nath, was the lady taken to the hospital? The women gown?
31 came to first order. 30 order again.
The first order is page 31, my lord, of the writ petition.
But thereafter, 23/11/22 order, kindly see it. 23/11. Honorable Court, she was produced before the Honorable Court, then Honorable Court said, the corpus shall be kept in state home for women at Jalikbari. The second last paragraph.
All right, then what has happened? Today, why the matter has been listed?
Well, yesterday the matter was fixed and the direction was to produce her again. Along with the previous order directed us to file an affidavit. The police is required to collect the certificates from all three schools where the petitioner went for the LP school and ME school. That affidavit we have filed, bringing all the three certificates, and the petitioner as well as the private respondent, they have filed their responses to that affidavit. Along with those affidavits and the person, she was produced yesterday, but the matter could not be heard. And Honorable Court expressed that the matter requires, since some disputed things are there, it requires a hearing, and accordingly place it before your lordships today.
So you are obviously appearing with state, and who else
Yes.
for the other respondents?
Kindly, for a moment, just see this prayer.
You
in
are
the
appearing
repetition.
for whom? That is the father,
Father.
and brother.
father
Yeah.
and brother.
For issuing both the lordship determination of the proper age of the girl.
Hmm.
If she is a minor, the result will be otherwise, and if she is a major as claimed by her, then it will entail some.
So what is the view of the Juvenile Justice Board
They found her major.
and the certificates?
Certificates, all are placed before your lordships. From the secondary board, second board of.
When did you file the affidavit?
We filed the affidavit on 22nd of December.
22nd.
Lordship. Well, before that, some reports were also placed before your lordships. The report of the Board of Secondary Education. It was also prepared. Affidavit on behalf of respondent number 2 and 3.
Just a minute.
Lordship.
Where is the affidavit of the state? Where is the state affidavit? Let's see.
Not I. Do I have a?
Yes, which page?
Internal page 5, annexure 1. This is the report of the LP school, report by the headmaster of the LP school. According to him, in the middle, on the basis of verbal declaration of the father, her date of birth was recorded as 21/10/2003, and her name was recorded as Anjuara Begum in the school admission register. She has left the school without completing the class 5, and hence no any school leaving certificate has been issued to her from the school. This is the LP school. Number Poshim Podukhat LP school, headmaster. Then annexure 2 is the translated copy of the report of the headmaster, Shamtila Pre-Senior Madrasa. The report said, I beg to state that Anjuma Khatun, son of daughter of Rajabali, so and so, got admission in class 6 at Shamtila Pre-Senior Madrasa on 2/1/16, and after completing class 8, she was given school leaving certificate from the said madrasa. As per admission register, her name is at serial number so and so. At the time of admission, no proof of date of birth of Anjuma Khatun could be produced by her, and on the basis of verbal declaration as to the date of birth being 3/7/2004, and her name is being Anjuma Khatun, she was given admission as per the Right to Children to Free and Compulsory Education Act 2009. Then annexure 3 is the ISA Jatiya Vidyalaya, where from she appeared in the HSLC exam. This also says according to this also, her date of birth is 3/7/2004.
And school leaving certificate says 3/7/2004.
School living certificate was also, we got a report from the Board of Secondary Education. In that report, we have handed over a copy of the report. Her date of birth recorded is 3/7/2004.
Where is that report you have given us?
Copy was submitted.
Is this the one? Is this the one?
Forwarding letter is 17th of December 22. I'm giving a copy. Original document received was placed before the lordship.
Yes, it is there. You can take it back.
Okay.
Yes.
Now, if lordship kindly comes to the prayer made in the writ petition, but the petitioner prayer is that kindly come to page 10 of the writ petition. She prayed that It is most respectfully prayed that your lordship would be pleased to enough to admit this petition, call for the record, issue a rule calling upon the respondents, particularly the respondent number 4, 5, and 7. They are the parents. To show cause as to why their action should not be declared as illegal, null and void, and to show cause as to why a writ of habeas corpus shall not be issued, directing the Superintendent of Police, Darong District at Mongoldo to produce the petitioner from the custody of the respondent number 4 and 5 for this honorable court. So pursuant to your lordship's order, she was produced before the honorable court, and pursuant to your lordship's order, she is now in the state home for women at Jalabari.
She is in the court.
Yes, on the way, she is coming.
Why? It was 11 o'clock was the time
True,
fixed.
true.
Then
Because of the traffic jam, the OC used to come from Dorong, therefore it's a Dhula PS case. He used to come from.
but he is asking the court to wait for his
Dorong.
arrival.
Kindly give us some time, because on the way I called him.
May I go out for 5 minutes?
Yes, yes. And what is the date of Nikah?
It is page 15, certificate.
Page 14 maybe, sir. 14. 5/7/22.
So what was her age on that day? If 3/7/2004 is taken as date of birth?
That is, my lord, 18 years. 18 years. 18 years. 3 or 4 months. Actually, my lord, at first she was sent to
5/7/2023.
district women committee of Dorong by landed judicial magistrate. That you keep the girl, but they, without knowledge of the court, sent the girl to the custody of parents. The parents and her brother, actually she is having a stepmother. That is one of the problems. However, she was mercilessly beaten in her various parts of body, and she even could not walk properly. So in this manner, her statement was also recorded. So the learned magistrate asked to keep the girl in their custody. But without the permission of the learned court, she was given to the custody of parents. There she faced so many troubles. Somehow she sent the news to her husband, Umar Farooq. Then Umar Farooq contracted with her. Then she said that I should be produced before the Honorable High Court, so that my desire should be expressed properly and my liberty menace is not curtailed. So in that way, we filed the habeas corpus petition.
All right.
Learned
Mr.
student-
Nath, where is the girl? Where is the corpus?
Within 10 minutes, they're reaching.
Then we'll have to pass an order and send a copy to the Director General of Police.
But
How could he take these things so lightly, DO?
but
We thought we'll wait for him.
kindly.
We are not accepting this. All right. What do you have to say? We'll close the matter, but what is the name of the OC? You give his name.
Well, he started.
That is his problem, not our problem. He should have been here at 11 o'clock. There is an order of the court. So we will not allow him to enter this room. And we are going to make some scathing observations.
I asked him.
Who has given him we'll ask him, who has asked him to come a little leisurely? That we'll ask him. Let him come. Thereafter, we'll drive him out. On whose instruction is he coming a little leisurely? That we'll find out. Let him come. When the order says he has to come at 11, he has to be here at 11. Otherwise, we will initiate action against him.
He informed that he
Whatever.
was stuck in the traffic.
That
He
is
was
his
stuck in-
problem. He should have been. That is, we'll initiate action against him. Yes, Mr. Chaudhary, what do you have to say?
My lord,
So if the girl is a major, then you can't have anything to say.
she is not a major.
No, the certificate says so.
Certificate is there, Lordship will kindly see that there are 4 date of births For date of birth, my lord, because as per the parents, she studied in another school where the date of birth was recorded as 31/12/2005. 31/12/2005. And the original hospital certificate also says.
Mr. Chaudhary, we will not go into that. Once there is a school living certificate
No,
issued
my
by
lord,
the board,
school living certificate.
you have to challenge it.
No, my lord, school living certificate cannot be the final word, my lord.
No, but then you have to challenge it.
Now, where from the school living certificate date of birth was found, my lord? Lordship will find that as per their own
So what is her date of birth?
date of birth, as per our record, my lord, 31/12/2005.
Where is the document? Show the document.
My lord, page 20 of the report.
Yes. Yes.
And in our affidavit at Annexure 1 also, we have annexed that document. And the person concerned who issued that certificate, they appeared before this honorable court. And stated that she was the authority to issue, and she, on the basis of record available in the hospital, she issued. But unfortunately, those records could not be traced because of the COVID situation. All records were destroyed, so she couldn't produce anything. But that has not been challenged by them, and that has not been denied also. So, my lord, it begins from that stage, and interestingly, lordship, when the second school came into picture, there the date of birth is shown as 21/10/2003. Where from it came, they say that on verbal declaration of the girl, they entered their date of birth. Then Shyamtila pre-senior madrasa, my lord. That is ME stage, lordship. There also, it is recorded as 3/7/2004 on the basis of declaration made by the girl only. No previous record was considered. And that was taken by the school at graduation level, ISR Jatiya Vidyapith, Dorong. And naturally, lordship, the last school sends the date of birth to the Board of Secondary Education, and they rely on that. So that way only, this date of birth of 3/7/2004 came into picture. Where it originated, there is no evidence, nothing of the sort. And the parents who gave birth to the child, they reared the child, they would not know, but some other persons who came in touch much at a later stage, they are aware of our date of birth. And lordship, in the writ petition, what is their prayer? That the persons who committed the wrong should be pulled up and asked to say why they shall not be punished for that. But there is no prayer that the date of birth of the girl should be determined or declare that she is a major. That prayer is not there in the writ petition. And if a minor, even with her consent, gets married to a person, whether it will be legally acceptable lordship. These are serious issues, lordship. And so far the Board of Education certificate is concerned, and some juvenile justice board certificate is concerned, we are not aware of that because we have not been able to have any knowledge.
What is this certificate you are relying upon at page 20?
Yes, Lord.
This has been issued in October 2017.
Lordship.
What is the basis of this? We are asking you this.
She came back and made her statement before the honorable court.
Oh, she really issued it. We don't doubt it.
Yes.
But on what basis this date was entered? That's what we are asking you.
On the basis of books of record in the hospital where the girl was born.
Where is that? Where is that? Where is that books of record?
She bought it, Lordship. And after examination, she took it back. Allowed to do it.
Where is it recorded in order of the court?
No,
She
that was
appeared
not
before this
recorded.
court.
He appeared.
She appeared before this court.
I will reply, I shall reply.
Huh?
I will reply.
She
A state-
appeared before this court.
Statement was not recorded.
No, but her appearance, is it recorded in order of this court?
Yes, yes.
Which order?
Doctor Vidyamati Hajarika. You are directing that on the next seat.
You said looking to- am I getting-
Yes. Yes.
So, Lordship, that being on record, Lordship, it cannot be said that it was wrongly entered or the certificate is a fake one.
Both are right. Which should the court rely upon?
Lordship, in this aspect, another aspect is the matter was dealt with by the trial court. Their evidence was adduced and it was recorded, and that court held her to be a minor. As against that, they came on revision. The revisional court also held that the order passed by the trial court was correct, not required to be interfered with. Thereafter, they did not proceed with the matter and it attains its finality. Thereafter, my lord, suddenly they came up before the honorable court in the writ petition. And in the writ petition, they did not whisper about this. Took a defiant stand. So, Lordship, the writ petition itself is not maintainable in that sense. Knowing all these facts, they did not utter a single word regarding her date of birth or the question of her majority or minority. It is a matter for trial and should be decided on evidence, allowing the other side to cross-examine the witnesses. Otherwise, Lordship, a certificate will come from the Board of Secondary Education. We shall have no say about it.
No, but you have to lodge an FIR against the Board of Secondary Education. Otherwise, we'll treat it to be correct. If you say it is a fake certificate, then you have to initiate a proceeding against that.
No, fake means in a sense, my lord, whereupon they got the date of birth, from the school last attended by the minor girl. What was the authenticity?
So, Mr. Chaudhary, you see,
Yes.
there are so many functionaries, so many authorities whose date of birth is taken as what is recorded in the school living certificate.
That is true.
And that is normally supplied by the school.
Yes.
But if that date has been accepted, and has remained on record. Whether it tallies with the actual date or not, that is the date which will be taken to be correct. That cannot be subsequently changed.
So my lord, in that case, the public document issued by the hospital authority at the time of her birth, though the certificate has been issued at a later date, but at the time of death it was recorded, birth it was recorded. So that also cannot be ignored, Lordship. So compared to that,
So what is to be done here according to you? There are two date of births issued by two different statutory authorities. According to one of them, which Mr. Mahmood is relying, she is a major. According to the other, which you are relying, she is a minor. Tell us what is the way forward, we'll do it. If Mr. Mahmood can satisfy us which is to be accepted, we'll accept it. If he can satisfy us that we should go by the board certificate, we'll accept it. If he cannot, then we'll reject his writ petition. As simple as that. We are not going to, in a writ petition, we are not going to go in all these things. The only question is, what is her date of birth? Whether she is a minor or a major. If she is a major, relief has to be granted.
that's why, my lord, I have placed before your lordship all the 4 date of births.
Which is to be accepted.
Question remains, that is the main question. Lordship, it will not be proper in my humble submission to accept the date of birth given by the Board of Secondary Education. Because
Why?
it has to have some basis where from there should be questioned where from you get it. So their answer will be, we got it from the last school attended, because school sends the date of birth of each candidate to the Board of Secondary Education. And they do not verify. They simply accept it straight away. But that school got the date of birth from another school where also there is no basis how they got the date of birth. Because they ought to have relied upon another certificate issued by the previous school. The previous school, the date of birth is something 21/10/2003. And they say that the girl herself declared that date of birth, that's why they recorded it.
No, wrong submission. That was parents' declaration, 2003. Parents' declaration.
But in
All right,
present,
where is the corpus is present?
This
Is
is
Miss
what
Nargis
circular
here? Miss Nargis, can you come forward? Please ask her what is her name and what is her date of birth. Can you help us a little? Yes, ask her.
Her name is Anjuma Khatun and date of birth is 3/7/2004.
And she wants to stay with whom? Ask her that.
She wants to stay with her husband.
All right. Presently, she is in the home.
Still,
Where is the police officer who's supposed to? You come here. What is your name?
Sanjay Sandal,
What time you are supposed to come to the court?
11 a.m.
What is the time now?
Actually, I am sorry.
No, wait. What is the time now?
But 12,
So you are late.
yes, sir.
You have violated the court order. We will proceed for contempt of court against you and send you to jail. But we will give you 1 day's time to file an affidavit explaining your conduct. If you are satisfied, we'll drop it. Otherwise, we'll be convicting you. for committing contempt of court. Stand there in the back and don't leave the court till we tell you. Go there. Who has asked you to come at 12? Who has given you this advice? You think this court proceeding is a joke? When the order said 11, why did you come at 12? Who has given you that advice? Who? Tell us who has given you that advice. Who has given you that advice to come at 12? You give an answer, mister, otherwise we will drop the proceeding right now. Who has given you the advice to come a little late? Who has given you? Who has given you that advice? Then why have you come at 12? All right, we'll see. Traffic jam, you should have been here at 9:30 if there is a court order. We'll deal with you. Go and stand there in the back.
And regarding certificate method, I want to explain something. Their certificate, that is a fact, it is evident on record matter. If your lordship kindly permit me, I may satisfy.
Yes.
Kindly see my lord, page 22 of the writ petition. This is the genuine certificate of another person. Here, my lord, book number is given 52/2017. Lordship has seen. Yes, 22.
Yes.
And in the bottom right side, my lord, there the initial of the dealing assistant. Book number 52/2017, and bottom right side is initial of dealing assistant, and thereafter doctor's signature. Now, lordship, kindly come to page 20. There is no book number. Page 20, here is no book number, which they claim to be the genuine certificate of the guard. Now, kindly see, they have applied this certificate on, they have applied it, there is no clear-cut thing, but thing is this, my lord, it has been issued on 10/10/2017. 2017. When there was some love affairs were going on between this girl and, so at that time they opened this. Now, the doctor came that I have put my signature. Now, at that time, my learned government, senior government advocate was asked, you produce, there is a procedure value. If a girl, if a boy or girl's date of birth is not recorded within 1 year at least, then Gavura will send a report to the DC, and DC will recommend that issue certificate. Those documents are not available at all. Every documents are there, but those documents are not available. Honorable High Court asked the Deputy Commissioner to depute an officer not below the rank of circle officer. He came that there is no record. So, first thing, there is no book number, there is no initial, and it is issued in 2017, whether her date of birth is 2004. Now, in 2003, her own parents stated before the school that my daughter's date of birth is 2003. Now, thereafter, another school she read, and from that school she appeared in the SSC examination. That was recorded. Every time that was accepted by all authorities. And as she has no birth certificate, so school, high school living certificate is the best document. We have got ample of judgments here we have brought. And my lord, this passport authority, UPSC authority, I have already, maybe they have also issued always the matriculation certificate as the genuine certificates. So these are my documents. I have got a lot of
All
judgments.
right, we'll just rise for 5 minutes and we'll come back and continue.
In the birth certificate itself. Thing is this, my lord, she has no birth certificate. Now everything is based on the matriculation examination certificate. And that is genuine, already report has come. And SP also verified the various schools records and found that she is major, and reports have been sent to my landed senior government advocate. Now, Lordship may kindly say this UPSC authority as well as passport authority. First condition of the UPSC authority is the as required document for as proof matriculation certificate, then standard certificate. Then Lordship kindly see the passport matter, that is number 2, transfer school living matriculation certificate in passport. In UPSC, first requirement is that, and in passport matter, second requirement is school living certificate. Now, my learned friend has said that you have not challenged that certificate. Perhaps my learned friend has not gone through the writ petition properly. I invite your Lordships, kindly come to page 5 of my writ petition. Para 2. Page 5, para 2. That the petitioner makes to state that she is a major humble girl, and since last few years, she was in love with Omar Farooq, age 24 years, son of Siddiq Ali village, Senibari, PS Dhula, district Dorang, Assam, and her date of birth is 3/7/2004. So we have said our date of birth. And this date of birth has been duly recorded in the SSS birth certificate of the victim girl, namely Anjuma Khatun. But by exercising fraud, the guardian of the girl managed to obtain a false birth certificate in the name of the victim girl on 10/10/17, showing her date of birth as 31/12/2005. But there is no book number or initial of the concerned dealing assistant over that certificate, whereas in genuine certificate, those things are duly recorded. Over and above, she has already married the petitioner on 5/7/2022 before the marriage and divorce registered at Abhayapuri. Before that, they also entered into an agreement for marriage before the notary at Jogipapa in Bongaigaon district, when she stayed for some time with her husband. However, for making a false birth certificate of the petitioner, already the police has taken a case against parents and brothers, and it is also learned that the police has already issued notices to them under section 41B of CRPC, but they are running away from police reachment. So I have mentioned, but I have not sought any punishment for them, because after all, they are my parents, right? But we have narrated everything. Now, so far, my lord, the school certificate is concerned, I have a plenary of judgments before your lordship. I will now satisfy your lordship on the point of legal points. That is, my lord, I have given these two lists. I have already given for honorable two judges. I have given 2 copies. Here, my lord, if I make the argument short in that manner, my lord, that I have already managed the matter in a chronological manner. 1997, 2 GLT 140 para 9 17 certificate para number I have given, my lord. Documents now para number 9 and 17. Now let us see para number 9 and 17. Let me show your lordship. Para number 9, first. The order of the government of India, while disposing of the statutory complaint, only revealed that there was no failure of justice in not continuing the delay of the application for correction of date of birth and for not changing date of birth in the affidavit of Major P.K. Panda, who at the time of filing the affidavit was working as a doctor, BRO, stated that the date of birth as entered in the school living certificate is mandatory documentary evidence for consideration along with other documents to examine delay latches. Now, lordship, the mandatory, it is mandatorily said, and those things are also recorded. Then, my lord, next page, make it seen. Next page, 146. In the instant case, request was made within the stipulated period of 2 years from the first enrollment. The petitioner's contestant that respondents are bound to consider the prayer is misconceived and untenable. Similarly, in paragraph 25, it was stated that decision of the Commissioner for Government of Kerala was not binding on the respondents. So now, lordship, may kindly see para 17, madam. para 17. For the foregoing reasons, the impugned judgment and order of the learned single judge is set aside and the appeal is allowed. Accordingly, the impugned order dated 7/2019-92, Annexure 2 of the writ petition passed by respondent number 3, as well as order dated so-and-so, passed by respondent number 1, Annexure 14 of the writ petition are set aside and quashed, and the respondents are directed to consider the case of petitioner appellant on merit in the light of the proceedings of the Commissioner for Government Examinations, Kerala, as well as the SSLC certificate showing the date of birth of the petitioner appellant as 21st January 1946. So SSLC means Senior Secondary School Living Certificate Examination. So our High Court, this is a division bench judgment, madam. Now, Lordship, I am showing another judgment of Honorable Supreme Court, 2001. I have given the there 4 SCC 5 page 5 to para 9. Now, para 9, Lordship, here it is a matriculation certificate has been accepted for the purpose of determination of age. Now, let us, Lordship, kindly come to para 9, madam. Para, given. 2001 4 SCC 52. Para 9, madam. We have heard the parties. It is settled law that at the fag end of career, a party cannot be allowed to raise a dispute regarding his date of birth. The case of the first respondent that he had intimated the company in so-and-so itself is not believable. In the application which had been filed by the first respondent, he himself had given his date of birth as 12/6/1927 and also mentioned that his age was 25 years. On the basis of this application and the matriculation certificate, the manager had issued a certificate. Thereafter, his service record, provident fund booklet, and even the annual reports contained the first respondent's date of birth as 12/6/1927. It is impossible to believe that for all these years, the first respondent was not aware of the date of birth in his service record or provident fund. So, my lord, it was said on the basis of matriculation certificate that was accepted, every document was prepared on the basis of that, and her parents were totally silent that in her birth matriculation certificate that birth of date of birth has been recorded. They are silent. All of a sudden, when she decided to marry Umar Farooq, then they awoke and giving this and that plate, they managed to get a certificate which is false. It is evident on recordment. Then, Lordship, another citation, AIR 2009 SC, AIR 2009 SC 3115 para 24, madam. Para 24. Second para, 24, second para, madam. On the other hand, there is a public document in the shape of school living certificate, Exhibit P2, issued by Headmaster, Government Primary School, Jabal, Jamrod, recording Kuldip's son, Elias Shamlal, to be the son of Sri Balakram. In the said public document, as such, Kuldip Chand Elias Shamlal was recorded son of so-and-so. So, school certificate was accepted for all these purposes, and the accordingly order was passed by. It was.
1 minute, 1 minute. Get the JJB Act, Juvenile Justice.
Then, my lord, another certificate, another citation, my lord. 2002. 7 SCC 719. Para 2, my lord. Para 2. We have hired counsel for the parties and perused the record. It is not disputed that date of birth recorded in the matriculation examination, as also in the service record, is 19/4/1935. It is also not disputed that the respondent joined service on 24/1/1955 if the contention of the respondent is that the correct date of birth is 3/2/1937, in that event, the respondent could not have been appointed in service in the year 1955, as she was much less than 18 years of age. The date of birth as recorded in the matriculation examination carries a greater evidential value than the evidential value attached to the certificate given by the retired headmaster. So Honorable Supreme Court has said that it's a greater evidentiary value, matriculation certificate. That is accepted. Such an evidence is not to be performed when admittedly the date of birth of the respondent as recorded in the matriculation examination was 19/4/35. The tribunal erred in relying on the certificate issued by retired headmaster. So that was not the board certificate. So it is clear that it is said that the matriculation certificate is acceptable. Now, so far, public document matter, section 74 of the Indian Evidence Act. Who is public servant? Now, the secretary of the Board of Secondary Education, my lord, he is a public servant. Headmaster is also public servant, my lord, because he is a
Mr.
salary.
Mahmood, when you argue points, apply your mind. We are not receiving evidence here. This is not leading evidence. These are all evidence act which
Yes,
come
sir.
into play. This is not a trial of a case where evidence is.
It's a public document, but that should be believed. So our only main thing is this, my lord. The question is date of birth. Now, this Honorable High Court, if there is any dispute about the matriculation certificate issued by the Sheba, then the other party may challenge it in civil court or any other forum. But for the time being, when the girl prima facie appears to be major on the basis of school certificate, which was recorded as per the statement of her parents at that time. At that time, she was 4 or 5 years, 6 years of age. So, first certificate 2003, there may be two. But that next certificate, that is 2004, even by that is matriculation certificate, or the ISA Academy, which school I appeared in the ISSL examination, that is also truly recorded. So everything, Board of Secondary Education says it is rightly recorded. So when all these authorities are saying correctly recorded, now they are disputed document. Not only disputed, is a fact document, because no record is there, no book number is there, no initial is there. Sometimes doctor may also sign different papers on good faith, but when it will come in the scrutiny of law, then everything would be properly adjudicated. So my submission is this, my lord. She is major at the time of her marriage, and she has been kept in the woman's house without any legal reason, and she has got married, and her liberty, man, should not be curtailed. So, my lord, my prayer is that she should be set at liberty. She may go anywhere she likes.
All right.
Yes,
Yes,
I have given the satisfaction.
My lord, there was a case against the so-called husband and other members of his family in the criminal court, and there I may read out, my lord.
No,
Order-
Mr. Chaudhary, you have argued. You want to start again.
No, my lord, I didn't conclude.
We
my-
will only go on one aspect,
Yes, my lord.
whether we should trust the school living certificate or whether we should trust the birth certificate. If we trust the school living certificate, there will be a direction that she should be handed over to her legally married husband and should be allowed to live as husband and wife as long as they want. If we trust the birth certificate and not the school living certificate, we'll dismiss the writ petition. Nothing else, nothing more, nothing less. We are not going to look at anything else.
So, my lord, I may be allowed to read this order, how it was dealt with by the trial court, my lord. Then lordship will find that they couldn't answer many questions. How
We
it was
will
determined.
not be able to do that because that is a matter which will not be relevant here. This is a 226 proceeding.
The decision cited by my learned friend, they were relating to the
Those are irrelevant. That you.
date of birth in connection with
Correct.
service.
Those have nothing to do with this case.
Nothing to do with it. My lord, my humble submission is, and an inquiry was held by the direction of this honorable court. A police officer investigated.
So what is the stand? You have objection to the lady going to her husband? You
Yes,
have
my
objection.
lord.
Why?
Because my lord, her parents say that she is a minor. She cannot take a decision on her own
Hmm.
where she would go.
So what is wrong with the petitioner?
No, my lord, nothing wrong.
Nothing is wrong.
Nothing wrong, but she is a minor. So until and unless it is determined that she is a major,
Hmm.
the whole thing will become illegal, my lord. Because if the marriage itself will be a nullity. They are claiming that they got married on such and such date before so and so authority, but that will come much later.
But that declaration cannot be given by a writ court. Writ court will have to go by the official records, documents.
That's why, my lord, my humble submission was, it had to be decided on examination of witnesses, cross-examination, etc. Purely on affidavit, it is difficult
And
to.
she has already lived with the petitioner as his wife. They have lived together and as husband and wife.
My lord, whether he is capable of taking that decision.
No, that's another matter. The court is asking, they have, after the marriage, they have lived as husband and wife. They have both lived as husband and wife.
I have doubts, my lord, because she was taken back to the CWC by court's order, then she was remanded to the custody of the parents. So in that sense, she didn't live as husband and wife. So, my lord, and coming to the report submitted by the police officer, the respondent 3, may I read from page 42 of his affidavit, what it says. The annexer 1, that is the headmaster number question 45 LP school. Lordship at page 42, kindly, possible fee. May I read, my lord?
Yes.
With due respect, I beg to state that Anjuara Begum, daughter of Rajiv Ali of Paschim Padukhat Pio Tiamtila, PS Hula, District Darong, Assam, took admission in number 2 Paschim Padukhat LP school in class 1. It is her own claim that they didn't read in the school which was suggested by the parents, and this name has been brought by her in the year 2010. Thereafter, she continued her studies till class 3, not up to class 5 also, in the year 2013. And from then on, stopped coming to the said school. Thereafter, there is silence as to which school she started attending. Her name has been entered at serial number 486 of 2010 of the school admission register. At the time of admission, neither she nor her guardian could produce her birth certificate or any other related documents as to her date of birth. On the basis of verbal declaration of the father, her date of birth was recorded as 21/10/2003. This is something very new. And her name was recorded as Anjura Begum in the school admission register. She has left the school without completing class 5. And hence, no any school leaving certificate has been issued to her from the school. And that was totally ignored. It has come out in the report. There is no explanation from the person who inquired into it. He didn't go any further to ask how this was done, where from this date of birth was got, and who furnished that. Then, Lordship, coming to page 44, Lordship will find Lordship, kindly at page 44, I'll read, Lordship. I beg to state that Anjura Khatun, daughter of Rajab Ali, so and so, got admission in class 6. She left class 3 in the previous school, where she prosecutor has studies at that gap between these 2 years. Then class 8, she was given school leaving certificate from the Saint Madrasa. As per the admission register, her name is at serial number 08 of 16. At the time of admission, no proof of date of birth of Anjuma Khatun could be produced by her, and on the basis of her verbal declaration, not the verbal declaration of her parents, as my learned friend claimed, as her date of birth being 3/7/2004. Her parents doesn't know, no one else knows, she herself knows that it is
So, Mr.
3/7/2004.
Chaudhary, that's what we are asking you. Show us one material based on which the birth certificate was issued. Why do we presume that that was also not done in the ipsy dixie of the father? Something you have to be able to produce, no?
No, the report itself says that it was her declaration.
We are saying if you want to rely on the birth certificate given by the
Hospital,
register of birth and death,
yes.
then please show us something which is contemporaneous, coincides with the time of her death, which will indicate that it was 2005 and not 2004. Is there anything to show that?
Lordship, that the doctor herself appeared before the honorable court and made her statement
She
that,
has signed it.
yes,
She has signed it. It was issued by the officer.
Yes.
But that's not a clinching proof.
it has to be done on some basis, books of entry.
Because it was done, how many, 13 years after the birth.
No,
12 to
Lordship,
13 years.
Lordship, I'll show you, Lordship, how things are done. Here, the certificates,
According to you, the girl was born in the year 2005.
2005.
The birth certificate was issued in 2017.
Yes,
What was placed before them in 2017 to issue the birth certificate? That is what we are asking you. That is all we are asking you.
Your Lordship, the registration number is shown as 5984 of 13. Registration number was from 13 and the date of issue was 10/10/2017. Similar is the case with the other certificate which is produced by the land page as annexure at page 22. Here also Lordship will find that registration number was 3831 of 14. But the date of issue was 22/9/17.
But the book number is given there.
The book number is given, my lord. That apart, they cannot claim that it was immediately issued. In their case
No,
of,
Mr. Chaudhary, will not drag it any further, but the only question we are asking you is that you say this certificate issued by this high school board that was prepared on the basis of some material which is non-existent,
non-existent.
correct?
Yes.
So therefore that certificate should not be relied upon. Rather, the certificate which was issued by the birth and death register, which shows her date of birth to be 2005, that should be relied upon. So we are only asking you that what is the contemporary material based on which this certificate was issued approximately 12 years after the birth of the person as per your projection?
My lord,
How do they know that it happened 12 years back, the person was born in 2005?
what intention that issuing authority might have. And Lordship will consider one aspect. That's why I have placed all this date of birth before your Lordship. How the last school, this ISA higher school, that issued the certificate, determined it is 3/7/2004. There is no basis. In our affidavit in opposition, Lordship, at page 62, annexure 5,
Yes.
it is written to Insars Panbari outpost. It is hereby informed you that birth certificate of Anjuma Khatun, daughter of so and so, date of birth 31/12/2005, bearing registration number so and so is found correct as per our birth register book of 2013. This is for favor of your kind information. Deputy Superintendent, Kuari Pukuri, MD Model Hospital. That certificate has also come, Lordship.
All right.
So-
All right, we are fixing this matter on Friday for orders, delivery of order. If you have any point to add, come up and we'll ask this, what is his name?
It's S Sanyal.
No, what S? Give the full name.
Sanjay Sanyal.
And he's what? He's holding
His OC Dhula Police Station.
OC Dhula Police Station.
Dhula Police Station.
All right. He will have to file an affidavit by tomorrow and remain personally present on the next day.
On Friday.
If we find his explanation is not acceptable, then we'll think whether it is a fit case to initiate contempt of court proceeding, and in which event the necessary orders will be passed. Take down, heard Mr. M. Mahmood, learned counsel, the petitioner. Also heard Mr. D. Nath, learned senior government advocate Assam, appearing for the respond numbers 1, 2, 3, and is it 6 also? Or 7? 1, 2. No, not aware. You are representing 1, 2, and 3. First of Mr. C. Chaudhary, Lawrence Senior Counsel, assisted by Mr. D. K. Bakshi, is present on behalf of respond numbers 4 and 5. Who is appearing for 6 and 7? None is appeared for respond numbers 6 and 7. First of, in terms of the order dated 2/1/2023 passed in this proceeding. The matter has been posted before this bench today. First up, there was an order upon the officer in charge of Dhula Police Station, that is the respond number 3, to produce the corpus before this court on 3/1/2023 at 11 AM. Full stop. Accordingly, this matter was called up, but the officer in charge of Dhula Police Station, namely Sri Sanjay, what is it? Sanyal. Sanyal has appeared with the corpus around 12 noon. That is after a delay of 1 hour. And on being inquired by the court, he did not appear to have any justifiable ground for his delayed appearance. Full stop. We are therefore of the view that the OC Dhula PS has deliberately failed to appear before this court at the time fixed by the order dated 2/1/2023, and therefore has caused obstruction to delivery of justice in this case. Full stop. Full stop. However, on the request of Mr. D. Nath, learned Senior Government Advocate Assam, we grant the respond number 3 to file we grant leave to the respond number 3 to file an affidavit within tomorrow, that is 4/1/2023, furnishing explanation in details as to the reason for which he had failed to appear in this court along with the corpus at 11 AM today. Full stop. registry to list this case again on 6/1/2023 as a fixed parted matter for further orders. So we'll deliver the order on 6/1. But on that day, the purpose need not be produced before this court.
But till then, she will be rescheduled.
Consequently, till the next date, that is 6/1/2023, the corpus will remain with the
State home.
state home for women
Women and children.
at
Children.
Jalukbari.
My lord, may we be allowed to file some affidavit in between
Now, what affidavit?
by the authority
Hmm.
who came up and deposed before the lordship here?
Mr. Chaudhary will deliver the judgment on 6/1. Whatever is to be filed, not filed, that we can't say anything. But the order will be passed on 6/1/2023. Under any circumstances, the matter will not be adjourned.
No, I don't prefer adjournment, but in between, if we can catch hold of the person who can explain why these things happen like this. Because verbal submissions made before the honorable court, but it was not recorded. If something,
We'll see if it is, we'll deal with it, but whether she should remain in the home or she should go to her husband, that order is coming on 6/1. That will come on 6/1. There is no question about it. These are matters which cannot be delayed. There is a reason why we have fixed it on 6/1. And we would also like to see how the police department is dealing with court orders. We'll find out what was the traffic condition today. We'll collect our own information, and if we find that any false statement is made, then it will have its own implication. But the affidavit better be on record by tomorrow. Otherwise, we'll direct personal appearance of the SP. Yes. All right, next matter. Mr. Chaudhary, we can't say anything about that. So as we have indicated, the only question here is what should be treated as the date of birth of the corpus here. Whether if it is 2004, she goes to her husband. If it is 2005, she doesn't go to her husband. Only things that will be taken note of is what is already on record, not what is now brought on record. That we cannot take note of. So on that basis, whatever be the logic reasoning, we'll give our judgment. It is still possible that we will accept the birth certificate. It is still possible that we'll accept the board's certificate. We need to do some research. We'll do it. And we'll come and deliver the judgment in the court. So if there is something already on record which you want to point out, but there will be no fresh arguments from either side on anything. Hearing is already concluded.
my understanding is, my lord, I'm not asking for any argument or adjournment, but if some material I can place before lordship, which can throw light in the adjudication.
Then we cannot deliver the judgment order on that day. You place it, we'll see, we'll deal with it. Placing materials, the court cannot stop. But we'll see, because if we allow his prayer, then she will go on 6th. These are human issues. We have to be sensitive to the cause of either side.
From the side of the parents also, it
Yes,
is
yes,
human
yes.
issue, lordship.
Yes.
Because she
Absolutely
she-
nothing.
she-
If
she-
a girl is a major, the parents have nothing to do about it. That's what the law says. Whether you and
That's
you
why-
and I agree personally, that's another
That's
matter.
why at the beginning I suggested that the only issue involved is the date of birth and the present age. Whether she is minor or a major.
That's
If she is a minor, everything goes the other way.
absolutely. We'll go by the law, not by emotions and sentiments. We'll go by the law. The law says a major is entitled to make a choice of her or his or her life partner. Nobody else can have a say. That's the law.
That is the law.
And we'll follow that. So only question is the board certificate more acceptable, or the subsequent date certificate is more acceptable? We'll have to give our reasons either ways.
Yes.
That's all. So whatever document you may or may not add, perhaps it will not make any difference. It will not make any difference.
No, only hindrance,
Unless you can show a judgment which says if there are two conflicting dates shown by a board.
public
school-
documents, two public
No,
documents.
these public documents, those are public documents.
Yes.
School living certificate and birth certificate. The subsequent birth certificate will override. Then maybe we can look into it. Other than that, difficult.
Why I submitting, my lord? I had judgments where comparison was done between public document and private document. There it held that public document will prevail.
No,
That's why-
but certificate by school living certificate is not a private document.
No, that is my submission.
No, that
Both-
too, he has also given a judgment.
No.
Retired school
Now,
teachers.
both being public documents, my lord,
Hmm.
both being public documents. The birth certificate is also a public document issued from the hospital.
That's all right. We'll
Yeah.
see. He has to remain personally present on the next day. And this matter will be listed at 10:30. This matter at 10:30. No, don't write 10:30. He has to remain present at 10 o'clock on the next date. Yes, all right.
For hearing item 5.
May please, your lord.
Yes.
No. Madam, before taking up the matter, madam, I'd like to point out there another aspect involved in this case, madam. That was already has been brought on record by way of filing affidavits, madam. That whether a person can be appointed by an executive order for to stand as a PP for NIA, madam. So we have brought it on record, madam, that section 25 describes the mode of appointment of a public prosecutor. That cannot be circumvented by an executive order, my lord. If your lordship will take up their affidavit, my lord, and our reply, my lord.
Bail has been rejected.
Or by the trial court, my lord. While hearing that it surfaced in another case, then the court wanted to exercise, carry out the exercise on these
So
aspects.
trial court found that you are having a lavish lifestyle.
Not me, madam, my husband, my lord.
Yes, that's the only ground.
Yes.
If you want to press for this, you will have to wait for a long time.
No,
Otherwise, we'll ask him what is
I
the-
pointed it out, my lord. My duty.
What is the material against her?
Lordship,
How can that be a ground, lavish lifestyle or whatever?
lavish lifestyle is one aspect of the matter, Lordship. On the other hand, Lordship, it is more or less admitted that the husband of the accused person here, A7 is the lady, A4 is the husband.
No, husband, we have
Yes.
nothing to say.
And he was the commander in chief of a militant outfit. And the money collected is put in her account. And this accused 4 and she, of course, some properties have been made out of that money, Lordship. And there is no tangible, Lordship, source of income, Lordship, and the statements of other persons show that this has been collected through terrorist activities, Lordship. And the money has been
But
put in
there is
her,
no allegation against the.
except for the money in her account, Lordship,
There's nothing.
except for the money in her account, Lordship.
She spent how many years?
5 years, 10
From
months. my lord.
2017, Lordship,
8 months, my lord.
2017, Lordship.
The incarceration clearly appears to be beyond 50%, even if she is convicted.
Absolutely.
There is no overt act on her part.
And as of now, Lordship, the charge sheet only says regarding the deposit of the money, and that money has been used by both. Husband and wife,
Madam,
Lordship.
before just winding up, my lord, I'd like to say here in this case, supplementary charge sheet was filed. Someone was issued. My problem was that, my lord, during that COVID period, I had 2 minor children. Now they have grown up, of course. I could not respond it. Other person who against whom similarly placed, my lord, another militant's wife, my lord, Anita Devi, I believe, Anita Devi. She was also issued someone, my lord, on receipt of the charge sheet. She came and appeared. She is on bail and still facing the trial. I only defaulted for that period, my lord. So I was arrested on the strength of an NBW, my lord, non-bailable warrant. And I had been tried by keeping me in jail, my lord. That's the only difference, my lord. Similarly placed, my lord.
Where is the order?
The impugn order, my lord, at page 80, my lord. Wow, what happened? 81, my lord.
No, Mr. Dev Chaudhary, we are not suggesting that you should directly draw an analogy. And it may not be even permissible. But supposing there is a corrupt official who, with the wealth generated from bribery, builds a house, and subsequently the officer is proceeded against under the PC Act. Can you also book his family members because they are living in that house?
Lordship, the ex-lordship, lordship knows the unlawful activities act and the PC Act on a different.
No,
footing,
different.
lordship.
But unless you can show that she also had a direct role or some overt act.
That lordship, I have
Nothing
not
else.
seen lordship, I mean, frankly, I haven't seen that. Her activity in terrorist, I have not seen lordship, but the money is collected through different places. It is deposited in Imphal, transferred to Guwahati, again transferred to Siliguri.
Seize
and it
seize
is-
the money and property if you find it is illegal. How can you lock up someone in the prison? That too under trial.
Lordship,
If you find the money is ill-gotten wealth
lordship.
and the assets have been purchased from that money, you may have some justification in proceeding against the property. But rather you are proceeding against the person enjoying the property. What have you done to seize the property? You have not done anything. So does it not somehow indicate a bit of a mindlessness on the part of? It is the property which will be tainted,
Yes, yes.
not the persons living inside it. Is it
Of
not?
course, the husband lordship.
The husband,
That is.
we are also
but
not
he
saying
lordship,
so.
Say lordship, that's, only the money has been put in her account lordship, which they have been enjoying.
Let us quickly have a read of the order. Yes,
Right.
where is it?
Page 82, my lord. The instant miscellaneous case is arising out of a petition. In 225 under 437 petition, Priya Devi seeking bail. Priya Devi is the daughter. Bail for her mother and Lakshmi Devi. He is one of the accused in the main case, special case number 2 of 2012, pending in this court. At this stage, the prosecution evidence. The same main NIA case arose out of NIA investigation case number RC such Guwahati. It may be mentioned herein that N. Priyo Kumar Singh, husband of the present accused seeking bail, is also an accused in the case and in judicial custody in Central Jail, Guwahati, along with his above named wife and Lakshmi Devi, for whom her daughter has moved this bail application. It is stated that N. Lakshmi Devi, the present accused seeking bail, was sent up for trial by supplementary charge sheet dated 30/6/2014 under section 120B, 420, 468, 471 IPC, read with 21 of the Unlawful Activities Prevention Act 1957, herein after APA. It is stated that due to the non-appearance of the accused N. Lakshmi Devi, that is what I am hammering, Mala, warrant was issued leading to her arrest on 7/4/84. 7/4/2017, and then since then she is under trial detention. It is further stated that the charges were framed against her by this court under section 120B, 420, 468, 471 IPC, read with 21 of the UAP. Her case, learned defense counsel appearing for the accused and Lakshmi Devi, it is stated and submitted that she has been in under trial detention since her arrest in 2017 for more than 4 years now. And her husband is also in judicial custody, and therefore the 3 children, including her 22-year-old daughter, petitioner are having to fend all for themselves all these years. It is further submitted by the learned defense counsel that with both parents being in jail, her daughter petitioner is having to look after 2 minor children as well. It is stated and submitted that the accused is innocent and the evidence adduced so far does not implicate her. Accordingly, stated and submitted that the accused may be granted bail. The prosecution white petition number 336 of 21 has filed a written reply objection to grant bail to the accused and Lakshmi Devi, Hard SK Lakal Lana SP, a senior PP, Nia, assisted by learned defense counsel and Kaushik. That is probably typing typography. It is stated and submitted that by the prosecution that there are sufficient material indicating the involvement of the accused of receiving proceed of terrorism, and that the bar of 43D5 proviso upper would be applicable, due to which bail should not be granted to the accused. It may be mentioned herein that an earlier bail petition on behalf of the accused and Lakshmi Devi was rejected by this court white order dated 26/9/18. Another bail application of the accused and Lakshmi Devi was rejected by this court through one of my learned predecessor white order dated 16/11/17, passed in miss case number such. Thus, the present bail application is the subsequent bail application. It is also stated in the bail application petition that no bail application of the accused is pending in the Honorable High Court. Section 43D5 proviso of the upper provides that if a person is accused of an offence punishable under chapter 4 and 6 of the upper act, then he cannot be granted bail if, upon perusing the case diary or charge sheet, the court forms an opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Well, this para 7 is very important. Well, in this context, it may be mentioned herein that in the case of Nia versus Zahur Ahmed Shah Watali 2019 5C, as well as Rojenboro Nia versus Nia 2016 4 full bench 803, it has been held that for the purpose of bail, the materials recorded in evidence after framing of charge cannot be looked into. The court has to restrict itself to the material on the charge sheet and the case diary. Well, here I will pause for a moment and will like to submit this honorable trial court matter has gone contrary to what was the decision of the full bench. If your lordship permit me, I can read the
Yes.
your lordship got it. Just for understanding the matter, my lord. Paragraph 30. Paragraph 31, I believe. Paragraph 31 is the finding, but let us just see para 1, my lord. What is
So
what
that's
is-
it. He is also saying, except the fact that
Yes, sir.
the
Nothing. my lord.
evidence is against the husband of
No, my lord,
the.
how the trial
Here,
court went
Lordship,
wrong. my lord.
Just pause for a moment, Lordship, if we read, she's charged under section 21 of the UAPA Act. The 21 says, Lordship, punishment for holding proceeds of terrorism. Whoever knowingly holds any property derived or obtained from commission of any terrorist act or acquired through the terrorist fund shall be punishable with imprisonment for a term which may extend to imprisonment for life. Now, this,
That will be established in trial.
that, Lordship.
She is in jail since April 2017.
Yes, Lordship.
And the court also went wrong, my lord, while writing the order. Why I say, my lord, if the full bench is looked into, my lord, it was contrary to what the full bench says, my lord. That's surprising, my lord. I'll read, my lord. The two appeals are before us on the reference. I have given the copy, my lord. Relying on Rajanboro and Watali, my case was rejected. Watali was in a total different footing, my lord, and Rajanboro versus Nia is completely on a different note, my lord. As to how much materials can be looked into while rejecting or accepting the bail, my lord. So the first para I am reading, my lord. What was the question framed, my lord? The two appeals are before us on reference made by the division bench to examine and decide the following two questions. Whether a person accused of an offence punishable after chapter 4 and 6 of the UAPA Act and is in detention for the same would not be entitled to consideration for bail under section 43D5 of the same Act, one charge frame against the accused for such offence. First. And the second is, what are the materials to be taken now? Whether the view taken by division bench of the High Court in Y. Brahmabandhu Singh that one charge is framed against an accused for an offence punishable under chapter 4 and 6 of the Unlawful Activity Prevention Act, and unless the same is challenged and set aside by a superior court, he would not be entitled to bail in view of subsection 5 and section of the Act lays down the correct proposition of law. So finding comes at para 31, my lord. In view of the decision made above, we are of the considered opinion that in view taken by the division bench in Y. Braja Bidhu Singh that one charge is framed against an accused for an offence punishable under chapters 4 and 6 of the ULP Act, and unless the same is challenged and set aside by Superior Court, the accused would not be entitled to bail in view of the provision to subsection 5 of section 43D of the ULP Act does not lay down the correct law. The view taken by Y. Brahmananda Singh is thus overruled. As a consequence, question number is answered in the negative by holding that a person accused of an offence punishable under chapter 4 and 6 of the ULP Act and is under detention for the same could be entitled to consideration for bail under section 43D5 of the said Act, irrespective of whether the charge is framed against the accused or not, subject of course to the limitation imposed by the said provision as having regard to thereof. Insofar as question number 2 is concerned, it has already been answered above by holding that Y. Brother Singh does not lay down the correct law. Reference is accordingly answered. So that
No, all right,
No,
the
I'm just
view
pointing
is
out,
not
my lord.
correct, but it is not exactly on this.
Yeah.
Here, the issue was whether bail
No.
could be granted after charge is framed.
Very good.
And the trial court has observed that the, except the charge sheet, no materials can be looked into.
No, he has said that it has been held in Radhanboro, which is not held, my lord, so the contrary. The judges right trial court just pointing here out, man. It has been held that for the purpose of bail, the materials recorded in evidence after framing of charge cannot be looked in, which is completely incorrect. And the court has to restrict itself to the material of the charge sheet and the case diary. Only the charge sheet and the case diary can be looked into, which is not correct proposition. The full bench has overruled that. But the judges say that no, that is the law. That is the proposition of law as per Brijananda Singh's case, my lord, not Radhanboro. Radhanboro ruled that part. You can look into every aspect, my lord, after the charge is framed, because the situation changes. One is investigation stage, one is after charge is framed, and one is now the trial is on, my lord. There are 266 witnesses, probably, my lord. 163 plus witnesses. And till date, my lord, 80 has been examined, my lord. 83 is examined and 80.
How many witnesses? 168.
63 plus supplementary 163 witnesses, my lord. Till now, 80 witnesses has been examined, my lord. 83 has been examined. 80 is yet to be examined from the main. Supply searches is more, my lord. But they have given repentance, so I'm referring myself to address that. They will be better position to say. And out of that, only 5 witnesses has been relied upon in my case. And they no way connect me with the case. If your lordship will kindly turn to next page 85, para 10, my lord. While rejecting my bail, these witnesses are taken. I have perused the statement of various witnesses examined during investigation. I have also perused the relevant documents submitted along with the charge sheet which were collected during the investigation. The statement of witnesses number 32, 33, 35, 46, 52 have prima facie materials regarding the alleged involvement of the husband of the accused as an important member of the band organization has been completed. KCP of Manipur. As per these witnesses, his involvement is by the name of Kashomiti. I have also perused the statement of witness Jayanta Kumar Dutta, Sushil Kumar Ray and KK Mishra. The statement of the witness indicates such aforesaid prima facie involvement of the husband of the accused in extortion activities on behalf of the extremist organization. Further, in his statement, witness 60, Sombu has stated about the lavish lifestyle of husband of the accused while they were in Siliguri. The witness also stated that husband of the accused did not have any apparent profession of source of income. I have also perused the document D87, which indicates banking transaction involving deposits of large amount of money in the bank account of elderly mother of the present accused Lakshmi Devi. In this regard, I find force of the defense submitted that extortion money collected on behalf of the extremist organization were routed to the account of late mother of the present accused, who is
So
the
is the
present
mother
accused.
of the applicant also accused here?
No.
She has expired lordship.
She has not been charged. There was also a beneficiary. On the one hand, the material also record do not indicate the apparent profession or source of income of the present accused Lakshmi Devi, and on the other hand, indicate that she has the proceed of the crime extorted by bank tellers. So thus on the materials
So
on
money is not stashed in the account of the applicant, but in the account of her late mother,
the late mother. So
not
her
in the account of the applicant.
it, from there, it has been again transferred to her. account.
Rewrote it, madam.
Rewrote it, Lordship, and in fact, to Guwahati, then again to Siliguri.
All said and done, my lord. I was not aware, my lord. My husband was reading the account that is, of course, there, my lord. But now for that, how long, my lord, my detention, my lord? We have
See,
also
nobody is aware of all these things till they are taken in custody.
only after
And
custody.
when they
people-
find good lawyers to argue, they
No,
really.
I will not give much emphasis, but I will rather rely.
But we will probably just look at it from that, what is the 50% of incarceration, which is that provision in CRPC?
Well, no, 436A is there, but here I'll a bit.
436A may not come in.
Difficult to differ, 436A, my lord, 437A. But when it is come to light, my lord, this half sentence will not come, my lord. It will come only when the period is determined, my lord, because
That's correct.
437A, my lord.
So more than 5 years.
5 years, yes. I'll give your lordship two judgment, my lord. 436A. I read my lord, I'm sorry, 436A. 436A, 18.437. Maximum period for which an under trial prisoner can be detained. When a person has during the period of investigation, inquiry or trial under this code of an offense under the law, not being an offense for which the punishment of death has been specified as one punishment under the law, undergo detention for the period. I'm wrong, my lord. A period extending to one of the maximum period for interest specified for that offense under the law shall be released by court on this person bond with or without surety, provided that the court may, after hearing the public prosecutor and for reasons to be recorded by in writing, order the continued detention of such person period longer than one half of the said period of release him on bail instead of personal bond with or surety. Provided further that no such person shall in any case be detained during the period of inquiry or trial for more than a maximum period of injury provided for the said offense under the law. In computing the period of detention under this section, for granting of bail, the period of detention passed due to delay in proceeding caused by the accused shall be excluded. Well, I think in the bracket, not being an offense with the punishment of death has been specified as well. It's not life, my lord. Death is the only exception, my lord.
There is no death. Death is
No,
not
no,
punishment.
no, that's life.
It's like,
Maximum is life, my lord. I thought it was life and death, my lord. But of course, I'm stand corrected, my lord. It's only death that is an exception, my lord. That is 302 cases and all these cases.
Yes.
My lord, in this podcast, my lord, I'd like to rely upon two judgments of the Honorable Supreme Court. One, the lordship knows it very well, that K. Najib's case, my lord. And one, my lord, I could find Najib was passed by relying Angela Harris Sontake case. This Najib case is by three-judge bench, my lord. And this Angela Harris Sontake is a two-judge bench, my lord. So relying on these two judges, the three judges was of the view that first I would like to rely on this Angela Harris. Connector, this is 2021 3 SCC 723. Before such, Angela Harris Sontake versus State of Maharashtra. If I go to the para 2 mile directly. Leave granted, we have heard the learned counsel for the party. Charges have been framed against the appellant accused under section 10, 13, 17, 18, 18A, 18B, 20, 21, 38, 39, 42 of the Unlawful Activities Prevention Act. So 11 UAP charge money. Read with section 120B of the penal code, amended to her, and section 387, 419, 465, 467, 468, 471, read with section 120B of the penal code. So 7 IPC and 11 UAP charge was there against this lady, madam. Undoubtedly, the charge are serious, but the seriousness of the charge will have to be balanced with certain other facts, like the period of custody suffered and the likely period within which the trial can be expected to be completed. The appellant accused has been in custody since April 2001, that is for over 5 years. 2011, that is for over 5 years. We are plus. The trial is yet to commence. In that case, trial didn't comment, but in our case, trial has commenced. Inasmuch as the learned State Council has submitted that on 9/5/2016 is the first date fixed for the trial. There are over 200 witnesses proposed to be examined. The appellant accused is the lady. She has also been acquitted of similar charges leveled against her in other cases. Taking into account all the aforesaid facts, we are of the view that the appellant accused should be admitted to bail. We accordingly direct that the appellant accused Angela Harish Sontake be released on bail by the learned trial court in connection with session case number 655 of 2011 arising out of CSI. We also make it clear that the learned trial court will consider and impose appropriate conditions subject to which the appellant accused will be released on bail in terms of the present order so as to ensure that the appellant accused is available for trial. In this regard, the learned PP would be at liberty to address the learned trial court as far as the conditions subject to which the appellant accused will be allowed to go on bail in the terms of the present order. Consequently, in the light of the above, we allow the appeal and set aside the order of the High Court. And this judgment was relied upon in that Nadeep's case, my lord. I'll just draw a few para, my lord, of the Nadeep's case, my lord. How similarly, I am also
Which
then on the
paragraph?
same
Which paragraph?
para, I rely upon 10, 12, 13, and 14, my lord. 13 is the main para which I would like to rely upon, my lord. Connecting paras are 10, 12, 13, 14, but the core paras are 13 and 14, my lord. I read the short paras. We may also refer to the orders analyzing similarly situated accused under UAP UAPA passed by this court in Angela Harish Sontake versus State of Maharashtra. That was also a case under section 1013A. So, my lord, all sections are there. Likewise, I also having 21 in Harish. Also in this case, 21. This court is also earnest effort to draw a balance between the seriousness of the charges within the period of custody suffered and the likely period within which the trial could be expected to be completed, took note of the 5 years. In my case, also 5 years plus. Incarnation and over 200 witnesses left to be examined and thus granted bail to the accused, notwithstanding section 43D5 of the UAPA Act. Similarly, in Sagar Totoram Gorkhe versus State of Maharashtra, an accused under UAP was enlarged for he had been in jail for 4 years and there were over 140 witnesses still unexamined. Then para 40, my lord. The facts of the instant case are more egregious than these two above cited instances. Not only has the respondent in jail for much more than 5 years, but there are 276 witnesses left to be examined. Charges have been framed only on 27/11/20. Still further 2 opportunities were given to the appellant Nia, who has shown no inclination to screen his endless list of witnesses. It also deserves mention that the 13 co-accused who have been convicted, none have been given a sentence more than 8 years rigorous in prison. It can therefore be legitimately expected that if found guilty, the respondent too would receive a sentence within the same ballpark. Given the 2/3 of such incarnation is already complete, it appears that the respondent has already paid heavily for his act of fleeing from justice. So, rest 15 para is that under trial prisoners' right, my lord. So, taking all this into consideration. Because I am charged under UAPA only one section 21, my lord. And someone was issued. I failed to respond to the summons, so non-bailable warrant was issued. Then, had I also appeared in the summon case today, probably I would have not been.
Where is the order passed in the co-accused case of the co-accused?
Yes, my lord, I have given, my lord. I think order we
We'll
are not.
continue at 2. We'll continue at 2.
Oh, my
Good afternoon, my lord. My lord, I am here to mention about a case, writ appeal, which was earlier mentioned court number 1, but due to shortage of time, my lord, it was said to be mentioned in the lower courts or court number 6. My lord. So it is an urgent matter, my lord.
What is he saying?
My lord, I'm here to mention a writ appeal.
Ah.
So it is a matter about panchayat matter, sir. concern election matter. Election. It is a matter relating to Panchayat election.
Hmm,
A non-confidence motion is about to move on 9th of January.
hmm.
So, my lord, kindly, if you allow to
Yeah,
allow
but,
the list.
why
this
are you
matter.
mentioning it before this court? This is to be done before the first court.
Yes, sir, it was done, sir, but due to shortage of time,
Shortage of time in what?
sir, sir, as Chief Justice said that it will be not entertained right now. It will not be allowed to be listed right now in court number 1. So he said that it can be listed in this court.
No, you give it to her. Check it. What is the matter? Check it up. When do you want it? When?
Tomorrow,
Tomorrow not possible.
the day after tomorrow.
Check it up. What is the? Yes.
But I was inquiring before the lunch break, my lord,
Hmm.
the order of Anita's bail, my lord. We have not procured the copy, my lord, but we have just now procured the details, my lord. On 24/7/2014, my lord, she was allowed to go on bail of 50,000 rupees with one surety of the like amount
Hmm.
and in default to jail hazard. And she responded on the summon she has received, so she was allowed to go on bail. In my case also, summon was issued, my lord, but due to COVID and the other pressing family
No,
problem.
COVID is don't,
Yeah,
Mr.
no, at that time, my lord.
Mr.
No, at that
Kumar,
time, at that time.
2017, you jumped and then you're.
No, no, not jumped, my lord. I was never arrested during the investigation of the case.
No, you were arrested in the month of April 2017.
Yes, my lord.
Then
That
where
is
was
after the
COVID?
charge sheet was filed, my lord.
So there was no COVID at that time,
Huh?
unless your client was in China.
Yes, my lord. Yes, yes.
Huh?
That way I went wrong, my
You
lord.
are- you
No,
are-
I was told, my
No,
lord.
it happens
Yes,
sometimes. Standard questions and standard submissions are made.
I'm sorry, my lord.
Sometimes it happens.
No,
This
but that's
was
okay.
there.
No, because I'm still livid with that 1920 situation, my lord. I'm so sorry, my lord. Absolutely, your lordship is right, my lord. But facts remain, my lord, due to pressing family problem, I could not appear before the court on time, my lord. Though similarly situated person has already been granted bail on the response of the summon, my lord. But I failed to respond the summon, my lord. So ultimately, non-bailable warrant was issued, and thereafter I was taken into custody, my lord. And that is the order dated 24/7/2014, my lord.
Hmm. All right, yes, what do you have to say, Mr. Chairman?
Worship, as I have noticed, submitted worship, it's only from what I have found in the charge sheet, worship. It's only that the amount that has been collected by way of terrorism, which is alleged offense, has been kept in her account, which she has used, her husband has used, lordship. And under section 21, lordship, if the of the NIA Act, I mean, UAPA, lordship. Could you look it up and could you? Whoever knowingly holds the property derived or obtained from commission of any terrorist act or acquired through the terrorist fund shall be punishable with imprisonment for a term which may extend to imprisonment for life and shall also be liable for fine. Here apparently, lordship, the accused number 7's husband is the commander-in-chief of a band outfit, lordship, and the money collected through those means have been kept in her account, which they were using, lordship. In so far as my lord, my senior friend's reference to the full court judgment is concerned, he has read the last paragraph, but lordship, I would just like to take your lordship to paragraph 13.
Paragraph?
Najib.
No, lordship, this full bench judgment of our high court, lordship, that is 2016 6 GLJ. If your lordship will see, yes, this bail being a matter of discretion, lordship, of course, this honorable court has the power to grant bail. But so far as what has to be looked into, that has also been stated in paragraph 30. If I may read it very slowly, Lordship. 30, we also have to keep in mind that we are considering prayer for bail at a stage post framing of charge. No doubt, section 43D5 of the ULAP Act is a special provision which has been introduced as a part of the state's response to the menace of terrorism, which is affecting large parts of our country, and that its conditions are extremely stringent. Here we have to bear in mind that by specifically mentioning the words on a perusal of the case diary or the report made under section 173 of the code, in the proviso to section 43D5 of the ULAP Act, the legislature has prohibited consideration of any material beyond the case diary or the report made under section 173 CRPC for consideration of bail. The case diary or the report made under section 173 CRPC, the inevitable consequence being that any evidence led after framing of charge would remain outside the purview of consideration for the limited purpose of granting bail. But having said so, it cannot be overlooked that grant of bail is a discretionary power conferred upon the court. Though extremely stringent conditions are imposed while considering bail under section 43D5 of the ULAP Act, it is one thing to say that discretion is to be exercised by the court with circumspection, having regard to the stringent nature and overall object of the provision, but it would be altogether different proposition to say that the court would have no jurisdiction at all to consider would have no discretion at all to consider bail once the charge is framed. But this basically relates to the second issue, whether after framing of charge, the bail can be considered or not. I agree, Lordship, bail can be considered, it's a discretion of the court. But what has to be looked into is, Lordship, till the submission of the report on the 170. Now here, apparently, Lordship, the charge sheet, apart from Lordship, the stacking of the cash in her account, Lordship, I would fairly submit, I do not see any link of her being involved in any other fellow. But husband is Lordship, A4 is a commander in chief. They used to collect the money, stash it in her account, Lordship, and then thereafter it was used. And it cannot be said also, Lordship, that she did not have any knowledge, because that is something that has crept down, Lordship, that she did not have any knowledge. Of course, Lordship, husband, if he's a commander in chief of a outfit, it's not probable, Lordship, the wife would.
Now, supposing the husband is acquitted, what will happen to the wife?
Lordship, then she
Everything
also,
falls.
she also,
Supposing the
Yes,
charge
yes.
brought against the husband is
yes,
by without a single word, the wife and the applicant has to be acquitted,
yes,
is it not?
yes, Lordship.
So even in this case, the conviction of the applicant would necessarily have to be preceded by conviction of
Husband. Yes.
And then the other aspect would be her knowledge.
Lordship. That, of course, it has to come out in the trial, Lordship.
So more than 5 years in detention,
I leave it. to
other
you.
co-accused
I,
similarly.
had she
situated.
appeared earlier, she would have been out. He would agree, Lordship.
Today we does not been before your lord.
Had Mr. Z. Kamal and senior senior counsel, assisted by Mr. K. Sinha and counsel appearing for the appellant, sole appellant. Also heard Mr. R. K. Dev Chaudhary, learned Deputy Solicitor General of India, bracket DSGI, assisted by Mr. L. Satyanarayan, learned counsel appearing for the respondent, bracket NIA. The instant appeal is presented against the order dated 14/12/2021 passed by the Special Judge, Nia, Assam, Guwahati in connection with Miss MISC stop. Case CASC case bracket Nia capital NIA bracket close number 21/2021 arising out of special SPL dot Nia case number 02/2012, thereby rejecting the bail petition filed by her. Full stop. The applicant N. Lakshmi Devi, LUXMI Lakshmi Devi, is one of the accused in special Nia case number 02/2012 arising out of case number RC-03/2011/NIA-GUW. Full stop. Upon completion of investigation, charge sheet was submitted against the applicant as well as her husband, namely N. Priyo Singh, N full stop PRIYO, Priyo Kumar Singh, as well as how many others? Priyo Kumar Singh bracket A4, A-4, and how many others?
Total 6, that means applicant and 5 others.
Charge sheet was submitted against 6 accused persons, including the applicant here and her husband N. Priya Kumar Singh bracket A4. Full stop. Based on the charge sheet. Based on the charge sheet. Full stop. Thereafter, summons were issued to the applicant. But when she had failed to appear before the learned court below, despite service of summons, a warrant of arrest was issued against her, based on which the applicant was arrested on 7/4/2017. Full stop. Since then, she is in custody. Stop. The learned trial court has framed charge against the applicant under section 120B/420/468/471 of the IPC, read with section 21 of the UAPA.
Unlawful activity prevention.
UAPA, where is that act? Section 21 of the Unlawful Activities bracket or Prevention bracket close Act, 1967. First step. The applicant is facing trial from detention. First step. The learned trial court has rejected the bail application filed by the applicant on 2 occasions. The letter being by order dated 14/12/2021. Full stop. By referring to the next paragraph, materials available on record, Mr. Kamar, learned senior counsel for the appellant, submits that the only allegation against his client is to the effect that the money collected by her husband by means of terrorist activities were partially parked in the bank account of the applicant, which fact was evidenced, evidenced by the lavish lifestyle led by the family Full stop. Mr. Kamar submits that there is no evidence whatsoever implicating the applicant in any terrorist or antisocial activity, and had the applicant appeared before the learned court below in response to the summons issued by the court, then in all probability she would not have been taken into custody. Full stop. In support of his above argument, Mr. Kamar has referred to the order granting bail to similarly situated co-accused persons in connection with, what is the case number?
Same case, man.
In connection with this case,
Same.
who had appeared before the learned trial court upon receipt of summons, full stop. Contending that the learned trial court had misread and misinterpreted the law laid down in the case of Nia versus Zahur Ahmad Shah Watali, at page 84 of Prabhu. Watali, reported in 2019 bracket close 5 SCC 1, as well as in the decision of this court in the case of Rogen. Is it Rogen? or
Rogen
Rajan?
Boro, madam.
Rogen.
ROJEN.
Rogen.
Rogen Boro versus
Rogen
Nia,
Boro and another versus Nia and another.
reported in
Reported in
2016, 4 GLT
2016
FB.
4 GLT bracket FB 803 to contend that there is no law which prohibits the court from considering a bail application merely because charge has been framed against the accused persons. Full stop. On such ground, Mr. Kamar submits that then you write. Mr. Kamar further submits that having regard to the period of detention in custody undergone by the applicant and the peculiar facts and circumstances of the case, this is a fit case where the applicant be allowed to go on bail during pendency of the trial. Full stop. The learned senior counsel has further submitted that out of the 183
63,
witnesses,
madam.
163 witnesses named in the charge sheet, only 83 of them have been examined till now, and the remaining witnesses, including those named in the supplementary charge sheet, are yet to be examined, which process will take a considerable amount of time. Full stop. Next para. Responding to the above, Mr. Dev Chaudhary submits that Seven accept the fact that a part of the money collected by the husband of the applicant would be traced to her bank account. There is no direct evidence implicating the petitioner, implicating the applicant in any other act of terrorism. First of, however, by referring to Section 21 of the UAPA Act 1967, Mr. Dev Chaudhary has argued that if it is established that the applicant had the knowledge about the fact that the money deposited in her account was drawn, DRAW, and drawn from acts of terrorism, in that event, she would be liable to be punished under Section 21 of the Act. And to that extent, it cannot be said that a prima facie case establishing the truthfulness of the allegation brought against the applicant has not been established on the basis of materials present on record. Full stop. We have considered the submissions advanced by learned counsel for both the sides and have also carefully gone through the materials available on record. Full stop. As noted above, the allegation brought against the husband of the applicant, namely N. Priyakumar Singh, is to the effect that he is an active member of a banned organization called KCP, within quotes, KCP of Manipur. And in that, in his capacity as such, the said accused person had collected extortion, had resorted to extortion from different quarters, thereby amassing huge amount of wealth. Full stop. The learned trial court had relied upon the statements of witnesses 32, 33, 35, 46, and 52 to arrive at a conclusion that a prima facie conclusion that the husband of the applicant was the member of a banned extremist organization. Full stop. Full stop. The learned trial court has also noticed that there are some bank transactions, including transfer of large amount of money in the account of the deceased mother of the applicant. Full stop. Full stop. According to the learned court below, such money was diverted in the account of mother of the applicant by the extremist organization and the applicant is also a beneficiary of the same. Full stop. Next para. It is no doubt correct that if it is established during trial that the applicant is recipient of bad money generated through activities of terrorism and had allowed such amount to be deposited in our account, knowing the same to be money collected through extremist organization, then she would undoubtedly be liable to be prosecuted and punished under section 21 of the UAPA Act. Full stop. However, whether the amount diverted to petitioner's account, if any, is a part of money collected by terrorist organization, and if so, whether she had knowledge about the same, are matters which will have to be established during trial. Full stop. It is also to be noted herein that the entire prosecution case, as projected through the materials available on record, hinges upon the fact that her husband is an active member of a banned terrorist organization. Full stop. It is therefore axiomatic that unless the charge brought against the husband of the applicant, that is the A4, is established, the prosecution case may not stand independently against the applicant. Full stop. All these factors will have to be examined. All these aspects of the matter would have to be examined during trial based on the quality and quantity of evidence brought on record. Full stop. Be that as it may, since save and accept the allegation of deposit of money in the account of the applicant and the apparent lavish lifestyle led by them as noticed by the learned trial court, there is no other evidence to prima facie implicate the applicant herein. And considering the fact that she has already she has already been in custody for more than 5 years. And also having regard to the fact that similarly situated accused persons have already been granted bail by the learned trial court since they had appeared before the court below in response to the summons, having regard to the taking note of the explanation furnished by Mr. Kamar, explaining the reason for failure of his client to appear before the learned court below, we consider it a fit case to allow the applicant to go on bail, full stop. As such, it is hereby ordered that the applicant, namely so-and-so, be released on bail on furnishing a bond of rupees 50,000 and 2 local sureties of like amount to the satisfaction of the learned trial court. Full stop. It will also be open to the learned court below to impose any other additional condition for release of the applicant on bail. Full stop. Before parting with the record, we make it clear that the observations made herein above are prima facie in nature and have been made purely for the purpose of disposing of this bail application. Full stop. Our observations as above shall not have any bearing at the purely for the purpose of disposal of the bail application. Full stop. That's all.
Yeah, but 2 things I'd like to point out. And so for the local surety is concerned, they are all inhabitants of Manipur, Myla. So that local surety will be meaning within the state of Assam, probably they will have difficulty to arrange bail, Myla. 2 surety will be good enough, Myla. Local means Assam of Napapon. They are from Manipur. We'll give landed documents and all things, but not local, Myla.
Delete the word local.
Delete the. Huh? Local to all. We'll give bailer, good bailer.
Good
Sure.
bailiff. In that
Local
case,
to
lordship, bail amount may be increased, lordship.
50,000 each. Agar dono ko dise pare. 50,000.
Local surety as well.
No, no, local.
He wants more money. You are making more money. They also want more.
Ultimately, the accounts are all praised by that they will get everything. And one more thing, Myla, if your lordship recording my submission, Myla, can just record one good submission, Myla. That during the course of the investigation, I was never arrested. And Myla, the charge sheet was also showing that not arrested, Myla. So that line.
Why we have granted you bail?
No, I'm just making it
So you add one line where submission.
submission.
Mr. Kamar further submit that
During
during
the.
the course of investigation, his client was never arrested.
Yes.
And if granted bail,
Ah.
the applicant will dutifully face trial.
Absolutely. That much of it. Much of it.
अपने घर वाले साइड में पैसे तो दिखा बना तो कॉल पर yes.
My lord, the item number 7, my lord. Yesterday, my lord, as Zahan, my lord, he did not do the case due to non-receipt of paperwork. But I have come to know, my lord, she is suffering from some ailment, so she is not present today.
What to do? People do fall sick sometimes. What to do?
Let it be on day after tomorrow, not tomorrow. Tomorrow I have some difficulty. Let it be on day after tomorrow. Yes.
69 lords. 69.
Who is the PP?
PP LCB lords.
Yes.
Your lordship, we have skipped the matters, your
You have
lordship.
skipped the matter. Why?
Yes, your lordship. Lordship, can it be on tomorrow, your lordship?
Lordship, it's 6 witnesses are there, lordship. let me start the case because they can reply for that, Lordship.
No, we'll not do it like this, because
Your
putting
Lordship,
one part heard after another part heard is not.
we'll continue it.
We'll do it tomorrow then.
Yes, sir.
Tomorrow you start. Tomorrow, how many witnesses?
6 witnesses, Lordship, only 6 witnesses. If Lordship here little bit and little bit.
All right, you start. Mr. Saika, you have some case?
Yes, in the next batch, not here.
In the next bench. There's another bench to do. Oh. Hmm. Yes, what is your,
This is the case, Lordship, intercepted the accused person on 7/5/2016, Lordship. And recovered 54.68 kg opium and 2.660 kg morphine, Lordship, from 4%, Lordship. And after that, Lordship, 4% has been convicted in this case, Lordship. And as much as 6 witnesses, no independent witnesses examined in this case, Lordship. 1 to 6, all are the official witnesses. And though all are official witnesses, only the PW3, who is the seizing officer, his presence has been established. Apart from his presence, others' presence are not established because no documents prepared. Whatever the documents prepared at the spot, no signature obtained from these official witnesses. That points we have brought in during the course of the PW's Lordship. In this case, after receiving an information by the seizing officer PW3 Lordship, they rushed to the Sorosoza Stadium, Lordship, and thereafter they intercepted 4%, Lordship. NCB 1 is exhibit 3, Lordship, that is page 1, Lordship, that is the secret
all right,
information.
just 1 minute. Let's see what is the list. Next bench. Hmm. Oh, what does that mean? We'll do it tomorrow then. There is a part-heard matter in the other bench. You can't go on adding part-heard matters. You
Can it
argue
be,
tomorrow.
can we can it be pardoned?
Who can take this case tomorrow? Some other bench can come and take it.
No, no.
Then tomorrow we are saying.
Lordship has extensively heard already, but in my first round of submission, Lordship, I could not place the various evidences. So the materials which will be very relevant to make out a case that it is not a case of discharge, I have to place those materials. So let us start from the FIR, Lordship.
Yes.
FIR at page 165.
My lord, on last occasion, Lordship indicated that both of us should be present. Actually, what I was thinking, my lord, let my learned friend conclude, then I'll give my reply.
Up to you.
May not be today, maybe another some other day. My learned friend will take a day.
Only thing is that it was agreed that it will be day-to-day hearing, today, tomorrow, that way. Lordship wanted to finish it at one go.
Yeah, naturally, because
Yes.
the facts are voluminous. Then
Exactly, that is what. So
then it is
that is why it was
What-
fixed today, tomorrow, and day after.
My lord, what I'll do, I'll give my reply on 9th. Monday,
No, but not tomorrow.
not tomorrow. Not tomorrow. Monday I'll give my some. Monday.
All right, let him.
Yes, I think my learned friend will take some time.
Develop.
So page 165 is the original FIR. Initially, the case was registered at Chanmari police station.
Page
Page-
65.
165, it starts. Dated 13/12/2019. May I just, very small FIR, also, may I just read it? Page 167. A source input has received that Sri Okhil Gogoi, son of so and so, Jorhat Assam, at present Nijarapar, Chanmari, Guwahati, being a founder, member, and president of a movement, namely Krikhak Mukti Songram Samiti, secretly merged its organization with the Revolutionary Communist Center (RCC) in the year 2009. The Revolutionary Communist Center was later dissolved and merged with the banned organization Communist Party of India, Maoist, CPI, Maoist. Accused Okhil Gogoi has associated himself with the proscribed organization CPI Maoist with intention to further the activities of it, including arranging of meetings and inviting support for the proscribed organization. He was closely associated with the top members, cadres of the said banned organization. He took responsibility of CPI Maoist in the state of Assam from Amitav Bakshi, a CPI Maoist leader. In furtherance of larger conspiracy of CPI Maoist, he arranged meetings with zonal committee, area committee, cadres, overground workers during the period between 2009 till date, and has visited several parts of India, including Delhi, in furtherance of this conspiracy to further the activities of the proscribed organization. Also, several acts of accused person have assisted, aided, and supported the activities of the banned organization with their full knowledge. As part of the larger conspiracy of CPI Maoist, he and others have knowingly abetted, conspired, advocated, incited the acts preparatory to commission of terrorist acts. The conspiracy of terrorist act is aimed at striking terror in a section of people of India by using inflammable substance, conspiracy to disrupt supplies and services essential to the life of the community in India. He has also conspired and committed acts in preparation for commission of terrorist act, including damage and destruction of properties of the state government. Through their visible representation and spoken words, accused persons Okhil Gogoi, Dhorjo Kaur, Manas Kaur, Biddu Sonwal, and others have abetted, incited hatred, caused disaffection towards the government established by law, using the Citizens Amendment Bill as a tool. Accused Okhil Gogoi, Dhorjo Kaur, Manas Kaur, and Biddu Sonwal and others have used passage of CAB in Parliament as an opportunity to promote enmity between different groups on the ground of religion, race, place of birth, residence, language, and done acts prejudicial to maintenance of harmony using visible representations and spoken words, thus endangering the security and sovereignty of the state, and which is prejudicial to national integration. So one SI of police Sanmari PS Monoranjan Mujumdar registered this FIR, and case was registered under section 120B, 124A, 153A, 153B of IPC, read with section 18 and 39 of the Unlawful Activities Prevention Act 1967. Thereafter, the investigation continued and charge sheet was filed. That charge sheet, Lordship will find that page 167, 169. 2-3 columns of here are very important. The charge sheet in the Court of Special Judges, so and so. State versus Okhil Gogoi is accused number 1. The sections are there. After the registration of the case at Sanmari, later on it was transferred to NIA. That document Lordship will find at page 161. The investigation was done by NIA.
Mr. Sesha, just a minute.
यही है ना registration. Okay. Chanmari. 161.
Yes,
So the first FIR was registered, lodged on 2019, page 168, which I have just read out. Lordship will kindly come to page 164. The Government of India, Ministry of Home Affairs, they issued a letter, order on 14 December. Last paragraph. Now therefore, in exercise of the power conferred under subsection 5 of section 6, read with section 8 of the National Investigation Agency Act 2008, the central government hereby directs the NIA to take up investigation of the aforesaid case. So page 164, and thereafter page 161, the case was re-registered by NIA. Page 162, action taken, serial number 13, called re-registered as case number NIA so-and-so dated 14/12/2022, discharging. NIA will take up the investigation as chief investigating officer. And after investigation was over, page 169 is the charge sheet. So there are basically 4 accused persons. So first charge is against Okhil Gogoi. The sections are there, lots of 120B, 124A, 153A, 154B, 18 and 19, 18 and 39 of UAPA. Then particulars against, they are at serial number 11, page 170, Okhil Gogoi, accused number 1, Dhorjo Kumar, accused number 2, Bittu Sonwal, accused number 4, and Manas Kumar, accused number 3. Then description of the case at serial number 15, brief of the case, which I am not repeating. Then 16, facts disclosed during investigation. For framing the charge, the contents of the FIR, contents of the charge, it's all are very relevant, Lordship, apart from the other evidences. So facts disclosed during investigation, serial number 16, 16.1. During the investigation, it is revealed that accused A1, that is Okhil Gogoi, had several secret meetings with the members of CPI Maoist and had sent about around 15 cadres, members of KMSS, in batches of 5 each to train in camps of CPI Maoist. They were imparted with training in their ideology, handling of arms and explosives, tactics of mass mobilization to carry seditious activities in the garb of protest activities. A1, along with his associates, since long has been organizing seditious activities disrupting government work in the state of Assam in the name of dissent activities in democracy, which have tactical resemblance with the modus operandi of CPI Maoist, a proscribed organization. 16.2, the tactical modus operandi of mass mobilization of for seditious activities in the garb of dissent, protest in democracy to disrupt government plans and policies to paralyze the government machinery in Assam is similar to the one imparted by Maoists in their training to misuse the privileges accorded in democracy. Accused 1, A1, A2, A3, and A4, along with others, had organized various meetings in the month of November and December 2019 and conspired to commit terrorist act by using inflammable substance to strike terror in section of people by causing widespread blockade in the state of Assam, thereby paralyzing the government machinery, causing economic blockade and disruption of services essential for life of community. Their provoking speeches caused enmity between groups, disrupted public peace, and caused widespread disharmony and disaffection towards the government established by the law. Mass mobilization of the modus operandi of CPI Maoist was done with the violence, leading to damaging of public property and grievous injuries to officials on their official duties. The accused persons conspired to promote public disharmony to violate section 144 CRPC across Assam, conspired to obstruct public ways, including railways, national highways, state highways, and internal roads in various places in Assam, cause damage to public utilities, thus blocking supplies essential for maintenance for life of community in India. 16.4, the lawful intercepts of mobile numbers of accused A1, A2, and A4 reveal their intention of seditious activities behind the garb of protest, and for the act, which were likely to strike terror in section of people of India by using inflammable substance to disrupt supplies essential for life of community in India, paralyzing the government machinery, causing economic blockade and causing enmity between groups, disruption of public peace and widespread disharmony and disaffection towards the government, assertions prejudicial for the national integration and promoting enmity between different groups on ground of religion, race, place of birth, residence, and language. Various video footages, speeches, and legal intercepts clearly establish the conspiracy of the terrorist act hatched by the accused A1 to A4. 16 conspiracy and subsequent provocation by accused caused blockades of supplies essential for life of community in India by inflammable substances, damage to public property, and injury to government officials on duty, which corroborate the conspiracy and seditious acts in the garb of democratic protest. Accused A1 and A3 had gone to Upper Assam while A2 and A4 were in Guwahati, and they coordinated with each other during this period to execute their conspiracy of terrorist act, seditious activities, and acts prejudicial to maintenance of harmony and national integration. CDR analysis revealed that A1, A2, A3, and A4 closely coordinated with each other in their conspiracy and subsequent execution of the conspiracy during the relevant period. Their connectivity chart is given below. The mobile phone and the data are given here, Lord, page 175, with their photographs. 16.9, page 176. In pursuance of their conspiracy terrorist activities, as defined in section 15(1)(a)(3) of UAPA Act, were executed at various places across Assam. This fact is corroborated by FIRs registered against the accused persons by Assam Police in various police stations across Assam as mentioned below. In Dibrugarh, regarding damage to CRPF vehicle, assault and grievous injuries to the driver of the vehicle on government duty. In Jorhat, regarding criminal conspiracy and unlawful assembly resulting in riotous type situation in various places in Jorhat, violation of section 144, obstruction of public ways including national highway, state highway, and internal roads of Jorhat town, causing damage to public utility by burning large number of tires. Ulibor, regarding disturbing harmony and promoting enmity between groups and communal tension, obstruction of public ways including national highway by burning tires, violation of 144. York also had similar things. Sibsagar, regarding provocative speeches, unlawful assembly, acts breaching public peace and order and promoting enmity between groups, obstruction of public ways including national highway, state highway, internal roads, causing damage to public utilities by burning large number of tires, trees, etc. Gaurisagar also identical. In Kamrup Metro, regarding blocking of highway at Koinadhora and attacks on traffic staff by violent agitators with stones, bricks, lathi, injury to traffic staff along with innocent people, and damage to government property using fire. Then Bokisto also identical things. Bokisto, there are 2-3 other cases. Further, a list of 64 FIRs against A1 as obtained from Assam Police establishes the antecedents of the accused. Then we are giving the videos also 16.6, 16.12. Not only incriminating documents, but tablets, etc. were all part of the record in this, this charge sheet. Details are given there, Lordship. Video footages, etc. (16.17), page 182. After going through the oral, documented, technical evidence brought on record during the course of investigation, it is established that accused A1 had several secret meetings with members of CPI Maoist and had sent 15 cadres, members of KMSs in batches of 5 each to train in camps of CPI Maoist. They were imparted with training with their ideology, handling of arms, explosives, tactics of mass mobilization to carry seditious activities in the garb of opposing lawfully established government. A1 along with his associates for a long period has been organizing seditious activities disrupting government work in the state of Assam in the name of decent activities in democracy which have a tactical resemblance to the modus operandi of the CPI Maoist, a proscribed organization. Further accused A1, A2, A3, and A4 along with the others have organized various meetings in the month of November, December 2019 and conspired to commit terrorist act by using inflammable substances to strike terror in section of people by causing widespread blockade in the state of Assam, thereby paralyzing the government machinery, causing economic blockade and disruption of service essential for life of community. The conspiracy and their subsequent provocative speeches caused enmity between groups, disruption of public peace, and causing widespread disharmony and disaffection towards the government established by the law. In pursuance of this conspiracy, the mob were provoked, leading to damaging of public property and grievous injuries to the officials on their official duty. The accused conspired to promote public disharmony, unlawful assembly in violation of Section 144 CRPC, obstruction of public ways, including railways, national highways, state highways, and internal roads in various places in Assam, thus blocking supplies essential for the life and community in India, using inflammable substances and thus subsequently causing damage to public utilities. Hence, accused 1, 2, 3, and 4 have committed offences as mentioned below. So 16-pointed investigation on the role of Akhil Gogoi, A1. A1's role is lordship. A1 has association with the proscribed organization CPI Maoist and had sent cadres of KMSs to train in Maoist camps. Accused A1 had an ideology on the spectrum of CPI Maoist ideology. A1 has conspired, advocated, abetted, advised the Commission of Terrorist Act as defined in Section 15(1)(a) of the UAPA Act. A1, by giving provoking speeches, promoted enmity between different classes of people on ground of religion, race, place of birth, residences, languages, which are prejudicial to maintenance of harmony. A1 made assertions prejudicial to the harmony of the national integration. A1 by his speeches caused disruption of public peace and causing widespread disharmony and disaffection towards the government established by the law. A1 conspired and orchestrated the widespread blockade in the state of Assam, thereby paralyzing the government machinery, causing economic blockade. He provoked the mobs to cause damage to public property and grievous injury to officials on government duty. The oral evidence, documents, material objects, and the technical evidence collected during the course of investigation are establishing the prima facie case against the accused to prosecute. More or less identical role has been played except role number 1. That is A1 in association proscribed organization sent cadres for training. Number 1 is not there for the other 3, but basically all others are same role. Third is at page 187. Akhil Gogoi, A1, for his prosecution under Section 120B, 124A, 153A, 153B of the IPC, Section 18 and 19. Dhorjo Kumar also more or less same lordship, the same provisions are there. So this is the main contents of the charge sheet. List of enclosures, page 188, Annexure 1 list of witnesses, Annexure 2 list of documents, and the material objects. There were lordship 19 witnesses, 19 or 20. 3 are protected witnesses and the rest are the regular witnesses. The list of the witnesses, lordship will find at page 189. All total 76 plus 1, 77 witnesses, but I will place only 19, which are relevant. And the main portion of that. And so far as documents are concerned, page 197, list of documents. Seizure memos, etc., including the vehicles which were damaged, objects will come. The transcript of the speeches, the social media uploads. So there are documents. Total document will be document up to 90 documents were there. From page 197 to 204. And the material objects, page 205 onwards. So here basically the various hard disk, tablets, laptops, then DVDs, mobile phones, pen drive, voice samples were recorded, everything were there, Lordship. Now coming to the statement of the witnesses. Some of the witnesses are their own person.
Who are the witnesses according to you who are important?
I'll place Lordship. 1, 2, 3 lines from almost 17 or 18 witnesses. In a very short time, I'll indicate those, Lordship. 2 witnesses I'll have to place. That is the 2 protected witness at the very beginning. And after the charge sheet was filed and during the course of hearing of the charge, the additional charge sheet was filed, wherein the 3rd protected witness was placed. So if Lordship is pleased to come to page 212.
Yes.
The English version of the statement given by the protected witness. So his identity is not known to me, Lordship. It is in seal cover.
Yes, yes.
So his statement was recorded by the IO, where the details can be. His statements were recorded by the Metropolitan Magistrate, New Delhi. Page 211. So may I read his statement, Lordship?
Yes.
Page 212. I went to Guwahati in the year 2008. There I saw Akhil Gogoi, who is head of KMSS. He was attending meeting with people. He was taking meetings regarding Mati Patta and Big Dam. I saw it. After that, I joined KMSS. Thereafter, I continued to join various meetings from village to village with them. One day after meeting, we 5 persons met one Sopon Bormon. Akhil Gogoi sent us to Orissa with Sopon Bormon for training with Maoists. I was also one amongst the 5 persons. Other persons were Sarat Khoikia, Dhrubo Gogoi, Dipali Gogoi, Lakshmi Gogoi. Sopon Bormon was not a member of KMSS. He was the link between Akhil Gogoi and Maoist. Further, Sopon Bormon took all 5 of us from Guwahati to Howrah. There one Maoist leader, Dadaji. His real name is not known, but everyone calls him Dadaji. Sopon Bormon returned to Assam after leaving us to Howrah. Thereafter, Dadaji took us to Bhubaneswar and then to Cuttack. Thereafter, 5 persons of Maoists took us to a hill of Orissa by motorcycle. After that, we reached the Maoist camp after walking some time. Maoist camp was on a hill in Orissa. On arriving at camp, we saw Maoists in uniforms. Everyone had a gun. We, all the 5 persons, stayed in the Maoist camp for 1 month. It was a shifting camp. The camp used to move every other day. There was 24-hour security in the camp. In the morning, we are made to do exercise, speak Lal Salam. Sometimes people used to go somewhere from the camp and sometimes come back. Sometimes there are 20 persons in the camp or sometimes 30 to 40. In camp, Maoist persons had AK-47, Injas rifle, pistol and hand grenades. We were taught handling AK-47 Injas guns by the Maoists. In the evening, we were given classes regarding communist countries all over the world and were told which is a communist country in the world. We are also given books to read. This process continued for some time. The name of the persons who gave us training was Lallu Commander, Commander Lakshmi. There we also saw Senior Commander Ajad. Later in the newspaper, we found that Ajad died. There we were taught regarding how to connect people. They also taught us how to protest, how to involve people in protest and to take forward the protest. One day he told us that the situation is bad now, so we have to return to Assam. After that, the next day, all 4 of us left the camp and they dropped us in bus in Cuttack. We reached Howrah, then Guwahati by bus. After coming to Guwahati, we met Ukhil Gogoi. Ukhil Gogoi asked us about what we saw and learned in the Maoist camp. Then we told him about everything that we saw and learned. Further, Ukhil Gogoi told us that the situation in Assam was not favorable to work together. Again said, Ukhil Gogoi told us that situation in Assam was not favorable to work together like Maoists do. After that, all 4 of my partners left. I don't know where they went, but I continued to work with Ukhil Gogoi. After that, for some days, I joined meetings from villages to villages in Golaghat, Dhemaji, Phadia, and Dibrugarh regarding the big dam in Assam and tell the people about the negative losses of dam and Matipatta. Thereafter, I stopped working for Ukhil Gogoi and joined an organization named Brihot Nodiban Protirodhi Moncho, which was opposing big dam. When I was opposing big dam, then police arrested me. This is all, nothing more that I want to tell. At this stage, the entire statements made by the witnesses read over to him, and after hearing the same, the witnesses say that he said that Ukhil Gogoi told 5 of us that the situation in Assam is not same to work as Maoists do. So we need to arrange people in Assam from what we learned. As Ukhil Gogoi said, we were making people ready from village to village. That time I got arrested, nothing more to tell. Are you making the statements voluntarily? It was his statement. So this is number 1, protected witness A. Then I have to take this honorable court to protected witness B, page 219. This was in English, this is not translated. His statement was also recorded by the Metropolitan Magistrate, New Delhi. The certificate, this is 161. Oh, sorry. This is 160. Yes, a certificate.
This is by the IOT.
Yes. This is 161 statement, Lordship. 219. In the year 2002, I came in contact with one Bipul Chakraborty of West Bengal who was working in Assam for People's War. By 2004, I got involved with CPI Maoist Party and used to attend their meetings in Guwahati. On being asked, I state that I have known Ukhil Gogoi since 1998 when he was the General Secretary of Cotton College, Guwahati. We got close to each other sometime during 2006. He met me and asked me to take some of his cadres, members of KMSS, and get them trained in ways of Maoist. I told him that I did not have the authority to do so, so I can talk to the leadership of CPI Maoist to make it happen. So I arranged a meeting of Ukhil Gogoi with Amit Bakshi, member of Central Committee, CPI Maoist, at near house of Britashree Tamuli, wife of Ukhil Gogoi in Golaghat, during September-October 2006. In the meeting, Ukhil Gogoi told Amit Bakshi that he would join CPIM after 2 years, but he needs his cadres members to be trained in the camp of CPI Maoist as soon as possible. Amit Bakshi agreed to the proposal made by Ukhil Gogoi. After 2-3 months, Amit Bakshi visited Assam again, met me at a restaurant in Guwahati, and asked me to convey to Ukhil Gogoi to select 10-12 cadres members of KMFS that he wants to send for training, and that later on at the training would be continue in such small batches. After around 20 days from this meeting, I met Ukhil Gogoi in person and conveyed him the message, as he does not talk about such things over phone. I told him to select 10-12 cadres members of KMSS, and then Amit Bakshi visit Assam. After 2-3 months, he would interact with those cadres members. Ukhil Gogoi agreed to do so and asked me to inform him when Amit Bakshi visits Assam next time. In January 2007, Ukhil Gogoi met me in Guwahati and told me to take Amit Bakshi whenever he comes to LP school near ancestral place of Ukhil Gogoi at Jorhat. During January-February 2007, Amit Bakshi visited Assam again and met me. I took him to LP school nearby ancestral place of Akhil Gogoi at Jorhat. There were 10 cadre members, 2 females, 8 males, along with Akhil Gogoi present at the location. Amit Bakshi gave a small speech regarding their work and aim to the members, 10 cadres plus Akhil Gogoi of KMSS there. Thereafter, he told that when time comes, they would be given training in 2 batches of 5 members each, as it becomes difficult to train in winter months. After the meeting, Akhil Gogoi had a secret talk with Amit Bakshi for a few minutes, the content of which was unknown to me. Further, Akhil Gogoi requested Amit Bakshi to arrange funds for programs of KMSS and expenditure that will occur on account of cadre members to be sent for training. Amit Bakshi told him that he would provide the funds to me and that I would hand it over to him later on. After 10-15 days of this meeting, I received an amount of 45,000 in cash sent by Amit Bakshi through one Indranil, member of CPI Maoist. I further handed over the amount to Akhil Gogoi in cash in Guwahati. During this meeting, Akhil Gogoi asked me if there is any information regarding when the training will start. I told him there was no information regarding it and I would inform him whenever I get any update. During April-May 2007, Amit Bakshi visited Assam again. Akhil Gogoi met him and told him that he needs funds for KMSS activities and expenditures of cadres members of KMSS selected for training with CPI Maoist. Amit Bakshi told Akhil Gogoi that he will bear their expenditure. Later in April, around Bihu 2008, a meeting was held in Rahmoya Gaon, Dibrugarh, Assam, which was attended by Amit Bakshi, Akhil Gogoi, Molan Laskar, Dharmeshwar Saikia, Aditya Borat, Dinraj, and Ajoy Sabar. I do not know the content of the meeting. After 3-4 days, Amit Bakshi, along with me, visited LP school nearby ancestral place of Akhil Gogoi at Jorhat and had a secret meeting with Akhil Gogoi. I do not know the content of the meeting. During summer season of 2008, Indranil conveyed me the message of Amit Bakshi to meet Akhil Gogoi and prepare batches of 5 cadres members to be sent for training. Akhil Gogoi prepared batches of 5 cadres members and sent me their age. Accordingly, I booked tickets for all 5 of them using the party fund of CPI Maoist. Those 5 cadres met me at Guwahati. Akhil talked to me and it was decided that second batch of 5 cadres will arrive at Howrah Junction after the first batch leaves Howrah Junction. I can recall name of only one member of the first batch as Dimbeswar Gogoi, resident of Merapani, Golaghat. I took the first batch to Howrah Junction from Guwahati by Saraighat Express. At Howrah, I handed them over to Indranil for their further journey to Maoist camp. I stayed at Howrah for the night. Next day, second batch of 5 cadres arrived at Howrah and I made them there as per previous plan decided by Akhil Gogoi. I handed them over to Indranil for their further journey to Maoist camp and I returned to Guwahati. After a few days, I met Akhil Gogoi and informed him that all 10 cadres have been sent to the Maoist training camps. Later in 2008, I received 60,000 in cash sent by Amit Bakshi through one Indranil. I further handed over the whole amount to Akhil Gogoi in cash in Guwahati for further activities. In 2009, Lordship will kindly mark this. In 2009, I went to Golaghat and met Akhil Gogoi there and it was decided that the third batch of 5 cadres, 3 males, 2 females, would be sent to Maoist training camp. I asked him to provide with the age of the cadres to book ticket for them. I came back to Guwahati and booked tickets for 5 cadres for their journey from Guwahati to Howrah Junction by Saraighat Express. I met them in a meeting at Guwahati, where Akhil Gogoi introduced them to me and briefed them about their visit to Maoist camps. I can recall names of 3 of those members as Dipali Gogoi, Kishore Das, Sarat Khoikia. I took all 5 of them to Howrah Junction from Guwahati by Saraighat Express. At Howrah, I handed them to Indranil for their further journey to Maoist camp. I returned to Guwahati. After some days, I met Akhil Gogoi and informed him that the third batch has been sent to Maoist training camp. On being asked, I state that the party has been providing regular funds to Akhil Gogoi for party, CPI Maoist activities, and special fund for special programs time to time. Further, I state that I can depose this statement only if the trial of the case is conducted outside Assam, otherwise there will be danger on my life as well as my family members. This was recorded by DR Singh, the IO. Now,
So these are some materials to
these are
indicate
two main, but the others, I'm coming now.
his links with the band organization. Is that what you're?
No, all are these two, they have given the background that Okhil Gogoi has connection with CPI Maoist.
That's what I'm saying.
In June 2009, that organization was declared as a banned organization. Prior to that, it was a regular organization. So that is a 2009. Here there is an indication that in 2009 also I went to Golaghat and met Okhil. So in which part of 2009 it is not sure whether it is before June or after June. Now that is another part. I will make my arguments, but just an indication. Now, who are the other persons who have given the statements? PW3. If Lordship is
Page number,
page number, it will be 212.
page.
I'll just 1 second. Two to 7. Deepak Mudoi.
Yes.
Deepak Mudoi in fourth paragraph, on being asked, I have to state that I know personally Okhil Gogoi. First time I met him at Bokakhat near Kaziranga during my Dibrugarh visit in the year 2018. During meeting, I took his mobile number 94350545524 and it was saved by me over my phone. Next page, Lordship. I'll not read the whole thing, which are very relevant for our purpose, Lordship. That's only I'd like to indicate. Next paragraph. On being asked, I have to state that at evening of 10/12/2019, I was at my home along with my relative, namely Montu Deka, brother-in-law, and one of my friends, Popullo Bushya. Further, I have to state that at around 20 to 30 hours, I called Okhil Gogoi and asked him, where are you? He told that he is in Dibrugarh, Assam. Again, I asked him, what will be the agenda for the Khatri Sonapur area for tomorrow? He told that just closed everything and blocked all roads, etc. After that, I told Gogoi, please speak with one of our leader. And I gave the phone speaker on to my friend Profulla Boisho. Okhil Gogoi told him that all roads across the state of Assam will be blocked tomorrow, and my friend replied that they will block the national highway. Again, Okhil Gogoi told that complete blocked. Further, my friend told that around 400 to 500 people will be gathered at Khatri and they will do it. On being asked, I have to state that next day, 11/12/2019, automatically national highway, all the shops, markets were closed. Further, I have to state that at around 20 to 15 hours, I talked with Okhil Gogoi and asked, will you come to Guwahati tomorrow? He told that they have to block everywhere in Assam and stop everything. I told him that we are doing here an advise what to do. Again, he told that they have to block everywhere in Guwahati, stop everything and ready for any kind of protest. This is Deepak Mudoi. So Deepak Mudoi said that Okhil Gogoi instructed him to block the roads in Khatri, especially. Blocking of roads, etc., comes under the Terrorist Act. That I will come from the UAPA. Next is Pranabjyoti Handi. In the first page, fourth paragraph. On being asked, I have to state that on 12/21/22 October 2018, Okhil Gogoi along with Polas Sangmai, General Secretary of AJYCP, had arranged a meeting at Olankar Hotel, Chanmari, and invited the executives of all 70 organizations of Assam. I had also attended the meeting. In this meeting, he addressed. So who addressed, Lordship? Okhil Gogoi. Okhil Gogoi addressed to all executives and told that he will not allow this bill to be passed at any cost, irrespective of any sacrifice required. Why I am trying to say, because the learned trial just said that he was not instrumental in anything. He was not a part of the conspiracy. All these activities which was initiated under these plannings resulted in wide-scale damage of the railway stations, roads, vehicles, government officials were injured. So these are the initial stage in October. Last 3 lines. After that, a meeting was organized by me at Rangpur Lodge at Ganeshguri along with the members of my organization, City Committee Guwahati, and told them that Akhil Gogoi directed me to conduct naked protest during the arrival of Prime Minister of India. However, that meeting did not happen. Prime Minister did not come. The Japanese Prime Minister also did not come because of the violence. So Akhil Gogoi directed me to conduct naked protest during the arrival of Prime Minister of India. Next page, Lordship. Second paragraph on top. On being asked, I have to state that on 10/12/2019, due to my illness, I could not participate in any protest, and whole day I was in Rangpur Lodge, Ganeshguri. At around 16:50 hours, Akhil Gogoi called me over my mobile and told that thousands of people marched in a procession at Dibrugarh to stop all essential supplies, market, national highway, etc. And now we are going to stop Sibsagar as well. Further, Akhil Gogoi directed me to inform District Committee Sibsagar that they need to announce over mic and bring the people to shut down whole Sibsagar. And further, he told that it would be better if we do it together. Then I told him that one Vishnu Paikya, Secretary BAYM of Town District Committee will manage at Sibsagar. Further, Akhil Gogoi told me to arrange everything at 1100 hours. Further, I asked to Akhil Gogoi that will there be a bike rally? Then Akhil Gogoi replied that bike rally, marching, whatever it could be done, we need to shut the town completely tomorrow. Further, I told Akhil Gogoi that I am going to tell Vishnu Paikya that he will call you. Further, I want to say that call could not be utilized with Vishnu Paikya.
So this person is PW what?
This is PW 4. And
Thank
after
you.
all this, the trial judge did not find any materials to make out a case for trial. Next, and these are their own people who are giving statements. They belong to the same organization or part of their organization, the consortium. PW5, Dibbojyoti Kharma. He is a principal. Presently, I am running Sinamara Jatiya Vidyalaya as principal. So, the third paragraph from bottom. Further, Akhil Gogoi told that, do close everything. Then I replied that we have to stop everything, and we visited each and every hostel. Further, I replied that all student unions will join the protest and will fight for Johar. Further, Akhil Gogoi told that do not lose hope, continue the struggle. Struggle is no difficulty, Lordship. Only thing is that don't burn the trains. Next page. On being asked, I have to state that on 11/12/2019, again a spontaneous protest was going on against CAB in front of Deputy Commissioner's office. I was also there in between at around 1200 hours. Akhil Gogoi called me that and he is coming to Jorhat. Further, I want to say at around 1800 hours, Akhil Gogoi along with Manas Kaur, he is also accused number 2 or 3 here. Three, Manas Kaur, reached at DC office and Akhil Gogoi delivered speech against CAB. On being asked, I have to state that at around 2000 hours, Akhil Gogoi, Manas and Lakhyajyoti Gogoi reached my home for dinner and night stay at around 21:30. Akhil Gogoi told me that someone calling him that police is coming here for his arrest and he left my house without saying anything. I can skip that for later part, nothing relevant. Now, one of the police officer who was injured, PW6, Tulumoni Dwara. Third paragraph, Lordship. On being asked further that on 9/12/2019, I, along with my PS staff and additional SP headquarters, was performing law and order duty at Chabua town as there was a gathering of 6,000 people headed and addressed by Okhil Gogoi. Headed and addressed by Okhil Gogoi, leader of KMSS. They blocked the railway track as part of economic blockade. I also saw that they had damaged a gypsy vehicle on duty under ITBP, Indo-Tibetan Border Police. We went further to stop them and tried to remove the blockade, but it was in vain as they were provoked by Okhil Gogoi. The leader of the crowd, Mr. Okhil Gogoi, and his associates criminally conspired against police and threw stones at us. One of the stones hit my mouth, injured my 2 teeth of the upper jaw, upper lip grievously. Another stone hit my head, but I was wearing a helmet. Immediately, I was shifted to Aditya Nursing Home, Dibrugarh, and doctor gave stitches and other treatment. One of my teeth had to be completely removed, and the another one is about to be removed.
1 second, please.
One of my teeth had to be completely removed, and the another one is about to be removed. It was an attempt of murder as a part of their conspiracy against police who were deployed there to maintain law and order. At the same time, the associates of Okhil Gogoi had damaged a white Bolero vehicle on duty under CRPF, and they had turned the vehicle over on its side on road. Mr. Okhil Gogoi and his associates, by way of their action, obstructed the police from performing their duties as well. The gathering of people was still being addressed by Okhil Gogoi leader, and as I got injured and was being shifted away from the site. Very categorical statement, Lordship. Next is Sunil Sonwal. He is a working president of KMSS. May I read from beginning, Lordship? I was born in so-and-so of Dibrugarh. My father was a farmer of ancestral agriculture and so-and-so. After passing matric, I am engaged in agricultural work on my own land. And in 2009, I joined KMSS due to ideology of KMSS for welfare of farmers, and I participated in Dharna at local village. As on date, I am holding the post of working president of KMSS of Dibrugarh. A very important person, Lordship. Then the telephone numbers, 2-3 paragraphs, the WhatsApp number, last paragraph of that page. Further, I state that Okhil Gogoi was leading protest in the state of Assam against CAB and CAA bill passed by Parliament, and all KMS associates under leadership of Okhil Gogoi was planning to stop the state machinery leading to block of highways. This is a terrorist act, Lordship. Protesting against CAB or CAA is not a terrorist act. But Okhil Gogoi, under the leadership of Okhil Gogoi, was planning to stop the state machinery leading to blockades of highways. Okhil Gogoi also visited Dibrugarh on 9/12/2019, and I, along with KMSS associates of Dibrugarh area, were present in Chabua. When Okhil Gogoi delivered a speech and provoked the public, the violent activities started in Sabua area, resulting in damage to government vehicles and grievous injuries to OC Sabua. After violent activities, all roads were blocked by protesters and situation was very bad. I also managed to be away from the scene, reach my home at around 20 hours. I had also seen Manas Kaur accompanying Okhil Gogoi. I met him again the next day, but they left my place. So a very important person of their own organization is making this kind of categorical statement. And the learned single judge says, a learned trial judge says that there is no material against him to discharge him. So when I was not doing any investigation. These are persons who belong to their organization. It has more strength in their statement. I'm not relying too much on the police statement, but this statement, their own working precedent. And it was none other any duress than Rahul Chetri. He is also a student of the university. PW8. I am, as above mentioned, I am a student and presently pursuing diploma in statistics from Dibrugarh University, Dibrugarh. We are two brothers and I am the elder one. My father is a cultivator by profession and my mother is a housewife. I am serving as a general secretary of Dibrugarh University Postgraduate Students Union since September 2018. Now coming to the last paragraph. On being asked, I want to state that on 11/12/2019 at around 2200 hours, I called Okhil Gogoi on his number 94350-54524 and asked Okhil that bill has been passed and what can be done. Then Okhil told me that only one option is there. We need to shut down Assam completely. This is a terrorist act under the definition of the UAPA Act. We need to shut down Assam completely during telephonic conversation. Again, Okhil told me that there is no other option but to shut down Assam. Again, I asked whether economic blockage has started as well, to which Okhil replied that everything has started. Okhil encouraged to continue the protest and shut down Assam. So another student leader is making this statement. PW7, Lordship. I have already placed PW7. Rahul Sepide. PW10, Lordship. Jugal Gogoi. He is the president of Satra Mukti Sangram Samiti of Dhemaji district.
There is page.
Page it will be 242.
Yes.
The third paragraph from below. Further, I have to state that I had talked with Okhil Gogoi, Manas Kaur and Bittu Sonwal many times over their phone numbers as above mentioned in connection of protest and other party work. On being asked, I have to state that as per direction of Okhil Gogoi and Bittu Sonwal, we are doing protest against CAB and CAA since November 2019. Further, I have to state that during period 9/12/2019 to 13/12, I was in Dhemaji and involved in various protests against CAB, now CAA. Then Moina Deka, PW11. He is the Joint General Secretary of KMSS of Assam. I am the Joint General Secretary of KMSS of Assam. I did higher secondary from Bejara, Tinslong. After higher secondary, I am doing farming and printing business. On being asked, state I have the personal know Okhil Gogoi, so and so, Dhojjo Kaur, Manas Kaur, Bittu Kaur. All their particulars, including telephone numbers, he has given. Further, I have to state that I had to talk to Okhil Gogoi, Dhojjo Kaur, Manas and Bittu Sonal many times over their phone numbers as mentioned above in various occasions relating protest, meetings and party work. On being asked, I have to state that in the leadership of Okhil Gogoi, we are opposing CAB, now CAA, and are doing continued protest against CAB in different parts of Guwahati and other places of Assam. On being asked, I have to state that as per direction of Okhil Gogoi during the period from 9/12 to 13/12, mass violation activities in Guwahati I was in Guwahati at the office of KMSS Gandhi Bosti, and during this period, I was in close contact with Okhil Gogoi and other leaders of KMSS. So who is coordinating, who is conspiring, Lordship, everything can be we can get an indication from these things, which will be supported by the telephonic interceptions. Then Kulopradip Bhagavati. Kulopradip Bhattacharya, last 3 lines of the first paragraph. Huge crowd of media persons were present there before we could execute the arrest. Okhil Gogoi started giving briefing to the media persons, and during his press brief, he again threatened to start agitation against CAB in the state of Assam. Same thing is said by the next Nitul Sonowal also. Now, Ritumoni Hazarika, PW 14. He is also a farmer. Second paragraph, Lordship. He also joined
This
KM.
Kulapati Bhattacharya is PW.
PW 12. Coming to PW 14, Lordship. Ritumoni Hazarika. He is also a member of KMSS. Second line in the first paragraph, first paragraph. I joined KMSS in 2013, and presently I am holding the post of District Sibsagar President and Organizing Secretary of Central Committee KMSS. Very important person in the party hierarchy or the organization's hierarchy. So he is the District Sibsagar District President, Organizing Secretary of the Central Committee of the KMSS. That is the Central Committee, state level. Further state that KMSS was planning to protest against CAA/CAB. Okhil Gogoi's chief advisor had called various meetings as organizing secretary. I was assigned to arrange KMSS members to participate in the protest in District Sibsagar and adjoining areas. On 10 December 2019 and 11 December 2019, I hold the protest in Sibsagar and Amguri by blocking national highways and trains. This comes under the definition of section 15. Blocking national highway and trains. On 10 December 2019, I called Okhil Gogoi on his mobile number 94350 from my mobile number so and updated him about blocking of train and other protests along with 200 to 300 associates of KMSS. Okhil Gogoi told me that he is reaching Sibsagar on 11 December and asked to arrange 200/300 boys of KMSS to execute strong protest against CAB/CAA, blockade of national highway and disruption for essential supplies. These are their statement. PW 16.
What is the name?
Jitul Deka. He has the business of supplying tourist vehicles, holding the post of General Secretary of Ohomia Juba Moncha. Second paragraph. His status. Last paragraph was it. I received call from Okhil Gogoi on 11 December 2019, in which he told me that he was in Jorhat at that time and thousands of people have gathered at Janta Bhavan for protest in Guwahati. Further, he repeatedly asked me to go to Janta Bhavan as well. In every place of protest, there was large-scale violence, large-scale damage of properties. And who is orchestrating? It is very clearly discernible from all these statements. The statements, it has come from the mouth of their own people, not independent people also. So that is why it is a fit case for trial. Paramananda Bora, PW 17. The maximum damage had taken place in Sabua. Half of the railway station was burned down. The station master has to flee away from the station. So what was Okhil Gogoi doing in Sabua here? Fourth paragraph from bottom, Lordship. He is a journalist. On being asked, I state that currently I am employed with Proceeding Times news channel as reporter.
You're reading Paramananda Bora.
Paramananda Bora, second paragraph, his identity. He's a reporter of Proceeding Times news channel. And now I'm coming to the third paragraph from bottom. I called Okhil Gogoi on 7/12/2019. During the conversation, I told Okhil Gogoi that we are organizing a demonstration in Jorhat on 9 December and asked him if he could be able to attend the program, to which he replied that he had planned to be in Sabua and they are planning a big program in Sabua. So what was the big program? From the other materials, we can very easily see what was that big program in Sabua. Then, because we have to see whether Okhil Gogoi was present or his other associates, accused number 2, 3, and 4 were present in Sabua or not, or in any of the place of protest. All the telephonic conversations, the tower location, everything is indicating that only, and photographs also. PW 18 Rajiv Gogoi. He is a businessman supplying of sand and stone. Last but third paragraph from bottom, 2 lines, to which he replied that he had planned to be in Panitola in the morning and in Sabua at night. After my conversation, I handed the phone back to Paramananda. So if I did the complete paragraph, it will give the meaning. On being asked regarding my talks with Okhil Gogoi during December 2019, I accept that I had talks with him over phone of Paramananda Bora. He had called Okhil Gogoi on 7/12/2019. After talking to Okhil Gogoi, Paramananda Bora handed me his phone to talk to Okhil Gogoi. During my conversation with Okhil Gogoi, I asked him to attend our program in Jorhat, to which he replied that he had planned to be in Panitola, that is in Dibrugarh, in morning and in Sabua at night. After my conversation, I handed the phone back to Paramananda. So these are the statements. Now the telephonic intercepts I would like to place. And one more, page 261. The photo.
261.
261. This is the protected witness C. This is a 161 statement. Statement recorded of protected witness C under section 161. On being asked about Okhil Gogoi, I voluntarily disclosed that I know he runs many organizations, namely Prikhok Mukti Songram Committee, Mod Mukto Ahom, Sah Shromik Mukti, Satra Mukti, Nari Mukti, and many more. Mr. Okhil Gogoi is the actual chief of all organizations. Mr. Okhil Gogoi runs his organization in Assam with Maoist style. He extorted money through his associates, party members, or volunteers of his organization. He first raises demand for money to the industrialists of non-Assamese and Assamese businessmen. If his demands not fulfilled, then he started to create pressure by using media and in the plea of RTI. He is very clever. He never protests at the time of purchase of land or any infrastructure construction. When businessmen invest large amount, he is in the middle of business project, then Okhil Gogoi demands money as levy. Mr. Okhil Gogoi demanded in crores for this type of extortion. He even gathered people by means of giving money, 250 to 150, and also provide them food and alcohol free. Another style of extortion he did, that he stopped lorries of trucks of supari, betel nuts, ada, ginger, haldi, dhan in highways, mostly in forest areas, by his party people. Mr. Okhil Gogoi does a settlement in yearly or monthly payment basis and as per scale of business. If businessmen not paid the levy to Okhil Gogoi, then his men beat driver and do damage to the truck. Even Okhil Gogoi demands from truck coming from Assam with fish, egg, pan patta. No truck can enter Assam from outside without paying levy to Okhil Gogoi. Okhil Gogoi also demands money from the businessmen of outsiders who runs wholesale business with sugarcane product in the false plea that they are making illegal alcohol. This extortion is running the name of Mot Mukta Assam. The leader of Nari Mukti, Mr. Okhil Gogoi, is also run a dirty business in the name of Nari Mukti. He trapped businessmen and high government officials in honey trap and then do blackmail to the persons and demand money for settlements or use them as and when required. To run it successfully, Mr. Okhil Gogoi does some good social work like settlement of rich-in families to create good image of Nari Mukti Sangathan. Another style of extortion of Okhil Gogoi is using tea laborers of Assam. In Assam, there are huge fallow land which are not tea garden after British period, but they adjoining area. If any person purchase the land and start to do some business, then Okhil Gogoi send his party members who belong to the tea labor union, Sah Shramik Mukti, and creates problem to the businessmen by agitation and dharna gherao, and then place his high demand for money to settlement. Sri Okhil Gogoi also runs illegal cattle business, which is smuggled to Bangladesh. With this, he gets support from the Muslim community. Mostly they are Silotia Muslims and Bengali Muslims. This business runs through the Muslim members of Prikhok Mukti. I know this because I personally experienced and suffered a lot. Mr. Okhil Gogoi demanded money 50 lakhs from me for 1 year. He threatened me that I will be killed anytime and if his people are watching me and my family every moment. He also declared that he runs much more strong and lethal organization than Alpha, a terrorist organization. I know Mr. Okhil Gogoi from last 5 years as an anti-social criminal and extortionist who creates terror to the businessman till he not go for monetary settlement. When I am not responded to his demand, he called me to do meetings with him, but I am not willing to go down to his illegitimate demands because I am not doing any wrong business and paying tax to the government of Assam as well as government of India. My family pressurized me to leave Assam and started newly in other states of India. Anyhow, Mr. Okhil Gogoi came to know about our plan. Then he also threatens me and I have come to know that his Prikhok Mukti Sangram Samiti has association with Maoists who have a network in all over India and they will kill me and my family in accident or other means. On being asked about identifying his photographs, I voluntarily ready to identify his photos. I know him since I passed class 10 examination. Okhil Gogoi is living in my area. Along with this, the photographs are also there. Memorandum of photo identification, page 263. And these are the photographs, Lordship, 265 in the camps. These were part of the additional charge sheet. And these documents, these photographs were identified by the protected witness B. That Lordship will find at 264, identify protected witness B. These photographs were some jungles in Odisha, Lordship. And page 267, his photo. So now, telephonic interception. Yellow.
Yes.
Now the call details. Is page in the original documents, Lordship will find.
Mr. Satyanarayan appears to be a little tired and hungry. Is he? He's not finding his pages.
So I have my markings here, but it have to be telling with lordship's record. That is LCR.
All right, Mr. Saikya, then we continue tomorrow.
Lordship.
How much time will you require?
I will
approximately?
require about 15-20 minutes here and another half hour. One maximum 1.5 hours. I have to place the judgments also.
Correct.
Actually, I'm trying to squeeze my submission.
Yeah, that's all right. That's all right. And Mr. Chaudhary will not reply tomorrow.
No, your lordship,
Huh?
on 9th, your lordship.
Why not tomorrow?
Tomorrow, your lordship, he might have some difficulty tomorrow. I don't have an idea about that. But your lordship, we will have to also show some of the statements, your lordship, part of the statements which.
No, certainly, you
will have to-
are entitled to argue your case, and after hearing only we'll take a view.
Lordship.
But breaking these matters again and again poses
Lordship, I
difficulty for
understand.
us. What happens is another part-heard matter comes in between, and we have to write out the judgments also. So please ask him whether he can.
I will.
Have you given it for tomorrow? Huh? I heard Mr. D.K. Sikal and a senior counsel assisted by Mr. L. Satyanarayan, the counsel for the appellant. Arguments have remained inconclusive. List this case again tomorrow for further hearing. Mr. S. Bhattacharya, learned counsel, is present on behalf of the respondents.
Okay.
So we'll continue tomorrow.
Yes,
Will it be possible for you to give a
I am
synopsis of-
preparing, lordship.
Okay. And you also give a
Lord-
synopsis
Lord,
of your
we are
argument.
also preparing.
See, the point is that we are not going to write an elaborate argument here. Only question is these materials, whatever was produced, was it totally insufficient for the court to proceed in the matter, or in other words, whether these materials could have been completely ignored and the court could have held that there is nothing to proceed against, no good ground to proceed first. If the answer is in the negative, it's going back with a direction to frame charge, and if they fail, then the matter ends here. If you fail, then what is the relief? That also you address the court. This
Relief-
court cannot frame charge.
No, that's why my submission will be to remand it back. Because this is one part on merit. The other part is a procedural lapse. They did not allow us to place all these things properly. We submitted the initial facts, then the other side argued. They give us a 1200 pages judgment, written arguments, and we are to give response. On that day, I appeared and said that kindly give me 1 week's time, because the previous night I was engaged. The honorable court said, we have on affidavit, he was also present, that you take a date because I have 3 other part-heard matters. So I will give it. My prayer was for 10 days adjournment. He agreed for 7 days. So it will be 7, 8 or 9 of that particular month. At 5:30, the honorable judge told us that one of my colleague will go and take the date on which date the further hearing will take place. Surprisingly, at 5:30, the case was said that it is closed. Tomorrow at 10:30, the order will be dictated.
So far as
That is troubling us.
So far as
And
that
all
part-
my officers were present. It was online because during that it was a COVID time. I did it from my chamber. All the NIA officers are there. Everybody heard that at 5:30 you send somebody to take the next day.
So far as
That gives a very bad reputation to our institution.
So far as that part is concerned, we have also filed an affidavit, your lordship, countering the averments, your lordship, made in the appeal, your lordship.
You are not agreeing with this.
Lords.
You are
We are
not
not,
agreeing.
we are not totally agreeing.
Not totally. One thing was whether there was a prayer for adjournment. Yes, he said that 10 days is too long. Then I said 7 days.
I said that 10 days is too long and I leave it to your honor to
And then the learned judge has closed the matter on that day itself.
That is your lordship, that day itself, and your lordship, so far as there is a finding recorded, so far as that part is concerned, why it is closed, your lordship? That
But
finding is there. Your
Otherwise,
lordship will
if he
go
had
through-
said that I'm not going to adjourn it, I would have started. I would have started.
All right, we'll deal with all this.
Lords, lords,
You place your case.
Yes, I'll place, Lord.
Let him, we'll deal with all these matters.
The court said that you take a date on which date of further hearing will take place. And at that time, I stopped. That is not permissible.
We'll
Lord.
examine, we'll examine.
It's a very serious matter and from a very respectable court. This is special court.
We'll
I am
examine.
not bothered about the outcome.
No, that's not the point. Outcome is,
Outcome is different, but these kind of things.
but if the Advocate General of the state, of course, he is appearing as a senior counsel, is making these allegations.
On affidavit, I have stated everything.
lordship will definitely take note of that, but your lordship, the learned judge is your lordship in his judgment has dealt with this point. Your lordship will go through that.
That's right.
The judge could have said that I am not adjourning it. You argue or I am closing it. That would have been a fair opinion of the court. But court said that at 5:30 you send somebody, take the next date because I have 3 other heard matters. So I cannot give the date immediately. I'll look into those matters and I'll give a short date.